For judgment, criminal appeal jail 118 public 22.
Appeal has been dismissed.
Daily list for orders, item 2.
Miss Bhuya was dealing with this matter. Today, she has some personal difficulties. Lordship, she has also filed some additional affidavit, no? So, Lordship. Oh, copy sir. Acha, acha.
What is this matter
For consideration of bail. Last Friday, Lordship has heard for some time, Lordship. He is in jail for last 10 years, more than 10 years, Lordship. Very weak evidence, conviction otherwise, I can accommodate for day after tomorrow, day after tomorrow.
But if we can't accommodate.
Lordship, that's true, Lordship.
Wait for 3rd January then.
Let the whole matter may be heard on 3rd of January. Because he is in jail, Lordship, for the last 10 years. I have filed the evidence. Okay.
You filed the evidence.
I have filed the evidence.
So we'll fix it on 7th January for hearing. the
For
main
final
appeal.
hearing,
If
Lordship.
for any reason it cannot be taken up.
My bail may be considered, Lordship.
Mr. B. Chakravarti, learned counsel for the applicant stroke appellant. We have also heard Ms. S. Jahan, learned APP Assam, who submits that. APP Assam and Mr.
I am appearing on behalf of respondent number 2, my lord.
And Mr. Your name?
Yes,
please?
Upadhyay.
S. Upadhyay, learned counsel for the respondent number 2. Ms. Jahan submits that this brief is being handled by Ms. B. Bhuya, learned APP Assam, who has not been able to come to court today. It is also her submission that an additional affidavit has been filed. Additional affidavit.
Additional affidavit, yes.
Affidavit has
Copy
been
has not been served.
filed in this case.
I'll tell her to serve.
The state. However, the said additional affidavit is not on record. Affidavit filed in which case?
I don't know, Ms. Bhuya said
Perhaps IA, because
I is 201.
Appeal or I detail number diba. Additional affidavit filed when? A copy of the additional
I criminal law.
filed on 3rd December. No, this is affidavit. It appears that the copy of the additional affidavit filed by the state is not on record. Full stop. Mr. Chakravarti, learned counsel for the appellant stroke applicant submits that his client is in jail for nearly 10 years now, and the evidence brought on record by the prosecution is very weak. Therefore, there is a fair chance that the accused will be acquitted in this case. Full stop. Considering the submissions made at the bar and on the request of Mr. Chakravarti, registry is directed to list the appeal along with his ID as a fixed item on 7th of January 2025 for hearing. It is made clear that if for any reason the appeal cannot be heard on that day, it will be open for the applicant to press the IA seeking bail.
Supplementary list for orders, item 12.
Yes.
Your lordship may kindly pass over the matter for the timing, your lordship. My senior is on legs.
You are who? What is the matter about? What is this IA about?
This is a second bail application, your lordship.
This is second bail application. No, what is the matter? Why are you going away?
Please,
Lordship, this is the second bail application against the
Where is the first order?
first order is at Annexure D, Your Lordship, page 34.
Yes.
Your Lordship, the mother of the accused appellant, Your Lordship, she has expired, Your Lordship, and the death certificate is on page number
Expired when?
on 24/11/2024, Your Lordship. It's in page number 17, Your Lordship, Annexure A.
Yes. Yes. So what is
Your
the,
Lordship may kindly consider the prayer for bail, Your Lordship. We have filed this is the second bail application, Your Lordship. This is to perform the last rite of his mother, Your Lordship.
yes, but on earlier occasion, the bail prayer was rejected by giving reasons.
Your
Injured eyewitness.
pardon, Your Lordship.
Last application was rejected
Yes, Your Lordship.
by giving reasons on merit.
Yes, Your Lordship.
Then.
This is a fresh ground, Your Lordship.
All right, mother is expired, but then that's not a ground to grant bail.
Your Lordship, if Your Lordship goes through the bail application, Your Lordship, we have elaborated some of the points, Your Lordship, on merits, Your Lordship.
Hmm.
Your Lordship would kindly
Yes.
Your Lordship would see that, yeah, this bail application, in this bail application, that there were two cases, Your Lordship. There are two cross cases, Your Lordship. While passing the judgment, Your Lordship, the learned trial court below has overlooked the cross case, Your Lordship. In the entire judgment, Your Lordship, there is no mention of the cross case that has been filed by the accused appellant. Your Lordship has, the learned court below has not placed any emphasis on the entire sequence of the cross case, Your Lordship. By overlooking that, the judgment has been passed, Your Lordship. And Your Lord, if Your Lordship sees, there are some grounds like the medical report, Your Lordship, that the accused has been stabbed thrice. There are three injuries, Your Lordship, but the
See, your Miss, may I know your name?
Himadri, Your Lordship, Himadri, age Bosho.
Acha, Miss Bosho. The bail applications, there are set parameters for the court to consider them.
Yes, sure.
Your client's bail application has already been rejected, right? So if you are approaching the court for the second time, there are parameters laid down for that. Are you aware of those parameters?
The fresh grounds is, Your Lordship, the
What is the fresh ground?
death of the mother, Your Lordship. He has to perform the last rites, Your Lordship, and his wife, Your Lordship, she's been undergoing she's she's suffering from multiple ailments, health issues, your lordship. And there are six, the accused appellant, there are 8 children, your lordship. So he's a sole breadwinner of the family, your lordship, and his wife, she needs medical treatment, your lordship, your lordship.
What is the ailment of the wife?
Your lordship, she has this chronic nasal congestion and has
Nasal congestion. Nasal congestion,
tonsillitis and all, your lordship.
tonsillitis, serious ailments. Yes,
Your lordship, may kindly peruse the
you
annexure.
don't have
B.
any objection, it seems
Now,
like.
if they want an interim bail for few days to do some
Hmm.
40 days ritual and all, that is okay. Because 1 month has expired. She died on 24th of November.
Hmm.
So almost 1 month will go. So interim bail for some days can be granted, but then not the bail under 389. But the interim bail, 40 days will be when? January.
Oh,
40 days will be again in January. From now onwards, there is no requirement.
But you don't have any objection, so then we can consider, you have not filed any objection.
Earlier we had filed on merits. Today, I think it has come up for the first time.
Yes.
So let me. Interim bail, we need not file any objection, I will.
We
But
consider till after the viewing vacation, then in the meantime, they will file an objection on the fifth, and after hearing, your lordship will take all, it can be disposed of immediately after reopening of the vacation, paperwork is ready.
So are you seeking interim bail or?
Yes, therefore, to perform the last rites, your lordship will consider till the reopening of the after the viewing vacation, and this can be disposed of it. Yeah, witnesses and all.
When is the last right? When is it?
Today, 30 days, normally they do it in 40 days. So now the holidays and all will be. Lordship will consider after reopening of the view for final disposal only. I'll argue I'll not take much time. I will put in a concise argument to finish it for once and for all.
not after Bihu, because second or third, the 40 days will be over.
Immediately second, third. View pisot lo aayega na ekta
Before Bihu, something else is there.
So 7 days opening and then no.
Which country, mister?
No, nowadays I'm in India.
Are you in India?
I'll be in Delhi, my pending works are there.
They will protest in other countries,
Then,
not crossing the sea.
no, in Delhi.
All right. So we'll record her name, but you must come prepared next time. We'll hear you.
Yes,
Mm.
I'll change.
I have.
Heard
to
Ms.
mention, your lordship.
Vishal and counsel appearing for the applicant. Under the supervision of Mr. B.D. Kaur, learned senior counsel engaged in this case. Also heard Ms. S. Jahan, learned APPSM representing the state. By filing this IE, the applicant has approached this court for the second time, seeking bail. First up, the earlier bail prayer made by the applicant was rejected by this court by order dated 24/2022. By giving reasons for doing so, full stop. The learned counsel for the applicant submits that in the meantime, the mother of the applicant has expired and therefore the applicant is required to, therefore, bail be granted to the applicant so as to perform the last rites of his mother. Additionally, it is also the submission of Ms. Boisho that the applicant's wife is suffering from some serious ailments and being the sole bread earner, his presence is required at home so as to take care of the family consisting of 8 minor children. Full stop. Ms. S. Jahan, learned APPSM, submits that if the prayer is confined only to grant of interim bail for performing the last rites, the state may not have any objection to the same. However, on merits, she be granted some time to file objection on behalf of the state. Since this IE has been listed for the first time today, the prayer made by Ms. Jahan stands allowed. Register to list this case again for orders on 6th of January 2025. In the meantime, objection on behalf of the state be considered. On the next, be filed. On the next date fixed, prayer for interim bail made by the applicant shall be considered.
Your Lordship,
Kindly take it up on 9th of,
9th of January, all right, 9th.
Your Lordship, there is a little correction, 2 minor sons and 6 daughters, Your Lordship. All of the 8 are not minor.
8 children, out of whom
2 sons are
there
minor.
are 2 minor sons.
Hi, Lord.
No, it'll be pending.
For hearing item 3.
9th of January.
In this matter, as regards merit of the case, I have something to submit, and then I have also submitted one written argument lodged.
My lord, the last occasion your lordship may ask, is there any SOPs or guidelines there regarding filing a appeal? There are so many lacunas we have found, my lord, loopholes there is found, my lord. After convictions, my lord, the states have not filed any appeal. That's why this issue has come before this honorable court, my lord. Now I have, my lord, query about this, my lord. The
Conviction or after acquittal?
But after acquittal and conviction, both the, my lord, in both the cases, my lord, the government has taken a decision whether it's go for appeal or not, my lord. Now, what I have seen, my lord, this is the incident of 2005, and the judgment was passed on 2019. And the accused, my lord, who was during the trial, my lord, absconded, my lord, in the year of 2018. Now, my lord, after that, my lord, the government have seen, my lord, there are not only this case, my lord, so many cases, my lord, accused has been absconded, but during trial or before trial, my lord. So the government has taken a decisions, my lord. A cabinet meeting has been set out, my lord, and they taken a decision.
When was the cabinet meeting?
My lord, the cabinet meeting, when it was said, it was not there, but a guidelines was, my lord, issued in the year of, my lord, 2022, my lord. And wherein, my lord, all these loopholes, lacuna, that has been rectified, my lord, and it's reformed, my lord. And now the government has, my lord, taken a decisions. My lord, every month, my lord, a monthly conference was chaired by DGP, and with AGGP, CID, make a presentation on the district-wise performances presented, and it is attended by the additional SP crime in person, SPs and OCs attended through online, my lord. Nowadays, every month it was, my lord, conducted by the DGP, my lord. And the new post of additional SPs crime has been created in the every districts to monitor all these things, my lord. And the officers are still posted, my lord. In every district, we have find, my lord, additional SP crime, my lord. And now SPs organize monthly conference crime every month in the district, my lord. It is done, my lord. And government has created a post of the, my lord. Now, your lordship, director of prosecution post has been created. Advertisement has been complete, my lord, issued, and it was closed, my lord. And now it's ready for, my lord. The interview is only left, my lord. After that, my lord, director of prosecution also be given. And now, after director of prosecution, when fully implementation, my lord, come, my lord, then this problem will be solved, my lord. And the PPs, additional PPs, assistant PPs, their interviews is going on, my lord. If this process becomes permanent, then the problems are, my lord, slowly resolved. And now regarding the conviction rate, it has been changed, my lord. Earlier occasions, my lord, it's very less. Now it's improved 5% to 22.6% nowadays. And regarding charge sheet has been improved from 45% to 66% nowadays. And these are the SOPs, my lord. If your lordship may permit.
Is it here? In this document?
No, this is the note prepared by my learned friend, my lord.
Achha.
These are the SOPs, my lord, which is published in the year of 2022. Before that, all these things was happens, my lord. And in this also SOP, my lord, very clearly it's, my lord, narrated, my lord, after passing a judgment, what government will, my lord, take steps, my lord. Your lordship may see it's quite eligible. I may be allowed to read, my lord, the
Yes,
point
yes.
wise, my lord. Yes. These SOPs was issued in the year of, my lord, 29/11/2022, my lord. So, number one, all superintendent of police and the deputy commissioner of police are directed to analyze each and every acquittals judgments delivered by the jurisdictional court. Number two, the district level committee consisting of superintendent of police, SPs, deputy commissioner of police, DCP, as the chairman of additional SP headquarters, crime and additional DCP, and senior most public prosecutor of the jurisdictions as a member should be formed for analysis of the judgment delivered by the jurisdictional trial court. Number three, the district level committee should analyze each and every cases both acquitted and convicted and give specific recommendations within a period of 21 days from the date of pronouncement of the judgment. Number four, it may be noted that the limitations period for period for filing appeals against acquittals judgment before the appellate court is 90 days, and the limitations period for filing an appeal for enhancement of sentence in a convicted cases is 60 days in view of the informations period. Sorry, my lord, limitation period. Timelines given should be strictly followed. The district level committee, after analyzing the acquittal judgment, should consider following aspects. A, if the acquittal is due to insufficient evidence, then the respective superintendent of police, deputy commissioner of police should educate the investigation officer IO of the jurisdiction in the crime conference crime review meeting by citing the above acquittal as example. If the acquittal is due to improper investigations by the investigation officer, then the suitable action should be taken against the investigating officer concerned after calling and explanations. If the acquittal is due to improper presentations of the case by the public prosecutor, the same should be brought on the record by sending a report to the Director of Prosecution with a copy of the Judicial Department, Government Assam. In this regard, necessary action can also be recommended against the public prosecutor if there is glaring the commissions or omissions on part of the public prosecutor. If the case is convicted, but the sentence is not commensurated with the nature of the offense, district level committee can analyze and recommend it, the appeal, filing an appeal for enhancements of the sentence. If acquittal was due to improper appreciation of evidence on record, then the committee should recommend for filing an appeal in the appellate court. If the acquittal judgment was passed by the magistrate court, appeal needs to be filed before the session court, and the district magistrate under section 378 so-and-so CRPC is competent to direct the public prosecutor to file an appeal. Petitions before the court of sessions of the offence are cognizable or non-bailable. And paragraph 6, point number 6, the district level committee should send the recommendations with regard to the filing of appeal within 21 days of the performing of the pronouncing of judgment to the respective district magistrate. 7, the district magistrate on receipt of the recommendations form, the district level committee should decide it within 21 days and pass his/her orders and direct the public prosecutor to file an appeal against the acquittal judgment before the jurisdictional session court. However, if the acquittal judgment is passed by the session court, the appeal should be filed before the High Court. Then the district level committee should send a recommendations to the respective range Deputy Inspector General of Police, DIG, Commissioner of Police within 21 days from the delivery of the judgment by the session court. The concerned range Deputy Inspector General of Police, Commissioner of Police will pursue the district level committee for recommendations and send his/her comments to the Home Department within 15 days from the date of receipt of time recommendations of the district level committee. The Home Department, state government will then consider the report, and if it deems fit, will direct the public prosecutor to file an appeal before the Honorable High Court within 21 days from the date of receipt of the comments of the range DIG, Commissioner of Police by drawing power under section 378 CRPC. 11, the timeline given should be strictly adhered to because any delay may result in the court not admitting the appeals. Only in exceptional cases we can file appeals even after the limitation period along with the delay continuations petitions. No judgment should be left unanalyzed by the district level committee even for enhancement of the sentence in conviction of the judgment. Steps 5 to 10 above be followed. This is for the strict compliance of the all concerned, my lord. This has already been issued after going through all lacunas, my lord. The government also seen, my lord, there are so many lacunas was held, my lord, that was not filed. There are so many injustice has been goes to the society, my lord. That's why this decision was taken, and it was now, my lord, implemented and it was followed. In my office, my lord, every day I have received 4-5 letters, my lord, regarding filing an appeals, my lord, nowadays. And every SP of the districts, my lord, they communicate me straightly, my lord, direct to me. If any, my lord, the accused was acquitted, they immediately contact me for filing an appeals, my lord. And home departments also, my lord, continuously touch with me for filing an appeals, my lord. This is nowadays, my lord, we have reformed. No doubt, my lord, earlier occasions, my lord, earlier before this, my lord, the guidelines, my lord, SOP, there are so many lacunas are there, my lord, we admitted, my lord. But we try to, my lord, reform all these things, my lord, nowadays, my lord.
All right, what about let's come to the facts of this case.
My lord. Now, my lord,
Yes,
immediately.
That's it, we can't go into all this. At the moment, they have said that they have steps. If I, whether the steps are good, bad, in one is that. Yes,
My lord,
coming to the facts of this case.
my lord,
This
yes.
is a case where there was no public prosecutor.
No, that was a.
That was a different case. What happened to the absconding accused?
My lord, yes. In this regard, my lord, I have already communicated the Superintendent of Police and the OCs, what they are doing after absconding this. They have filed a submission a report to me, my lord. This is the report. Now, it will change this. This is the report, your lordships.
It's a sit-in. One second.
The last paragraph, your lordships.
So, this report shows that nothing was done so far. Only after the court order,
My lord, yes.
very, very mild efforts are being.
No, my lord, I have pressurized them, my lord. In one cases, my lord, similar situation has been arises in chief court, my lord, in the division bench, criminal matter was taken. Where, my lord, for last 25 years, this person was absconded, my lord. We make an effort, my lord, this court has made an effort. And after that, my lord, that person was apprehended in, my lord, Lidu. So, my lord, we have made an effort, my lord, to continuously, my lord, monitor, my lord. They have no mobiles, my lord. Even they have tried to, my lord, trace in the, my lord, CDR also, but they did not use any mobile phone. So the police has made an effort to, my lord, regarding the arrest this person. I am saying, my lord, they have published in the newspaper also their photograph, if any, my lord, it should be placed in every district and every country.
When did this accused, when did he abscond?
Since 2018, my lord.
All right.
My lord.
So last 6 years, nothing has been done practically.
My lord, yes. That is, my lord, yes. I already, my lord, informed they
So we'll.
They said that, my lord, they already shows, my lord, at that point, I am not there, I am now newly posting here, my lord.
That's
That
all right.
officer has been
Ask
changed.
the Concerned SP to come.
My lord,
with
yes.
The record.
But in the executing officer, there are, in the paper book, there are papers where he had tried all those PNA and everything was issued after 2008.
My lord, yes.
That is there in the paper book.
No, PNA and what was? These are all formalities.
My lord, yes, that formalities was done, my lord. That is no, my lord, there is regarding formalities, there is no such complaint. Prosecution will take care of it. But regarding absconding, police has failed to arrest this person, yes. It is the failure of the government, my lord, I admit it, yes.
We will monitor this because you see, this is a case where there is eyewitness, the injured eyewitness is there.
My lord, yes.
We will take everyone to task.
My lord, whatever it
Mr.
may be.
Ahmed, we are not hearing this matter today and concluding. It will take time. This is not a case just on mere hyper technicality due to the complete wrong understanding of the sessions judge. Acquittal will not be possible. We'll have to see the end of the matter. So no hearing today and this will remain tied up. We are going to monitor. The SP has to find the, or else we'll revisit what is the mechanism followed by the state.
Apart
They are,
from,
the mighty state is unable to locate a absconding accused,
my lord, yes.
then we have to see what else is to be done.
Of course, my lord.
This is not a case of circumstantial evidence. This is a
Uh,
case of India and we will ask the registry also to look into, examine this judgment and examine the issue in the vigilance side. How this judgment could have been passed by the sessions judge.
Lordship,
Same evidence, eyewitnesses implicating all the accused.
evidence of PW to that your Lordship may kindly see once again, Lordship, that whether she is reliable or not.
That
But
will
that-
come to it. We'll hear the matter,
Okay.
but we'll not conclude it today. Be sure about it.
Lordship.
So on the merit of the case, do you think, does the state think it's a case of appeal against acquittal or not?
My lord, yes, it's a fit case for appeal against acquittal, my lord.
Then why no appeal has been filed?
My lord, yes, that lacunas was held, my lord. It's admitted fact, my lord, government has, my lord, that's overlooked this part.
Even now, appeal can be filed.
Yes, yes, my lord. We can file, my lord.
No, we can't let this criminal justice system to be hijacked by some people just because some district judges don't do their work sincerely. Some police officers are totally apathetic to these things. We are talking about those days.
My lord, yes.
Recently, we are aware that a lot of things has been done by
My
the
lord,
government.
yes.
Nothing, no comments on that.
My lord.
But we have to see whether these measures are actually delivering. This is serious business. Otherwise, anybody is committing crime and
My lord, yes,
getting
of
away
course, my
some
lord.
lacuna here, some lacuna there, lethargy. Yeah, nobody has the energy, the interest. Find out something. There is in every case there is something that is not going to work out in this court, Mr. Ahmed.
Lordship.
You can argue,
Yes.
but on that technical ground, we'll give an answer. We are not going to acquit your client on that.
Apart from
Unless
that,
you show that the injured eyewitness's version is,
yes, I will argue on that as well.
you have to tell us if you don't file an appeal against acquittal, then you have to tell us why despite pointing it out.
No, my lord, we are discussing with the government, my lord. We are going to file an appeal, my lord, in this case, my lord.
You have to tell us.
There is some delay, my lord, in this regard, my
You
lord.
can't make a mockery of the criminal.
My lord,
justice
yes, of
system
course,
like
my lord.
this.
Yes. We are also very much concerned about the society, my lord. So,
But Lordship, see once, the other witnesses, apart from PWT, other witnesses, there are contradictions. In totality, they have not stated anything before the.
What about the wife?
Her wife, in her examination in chief, she said about 4 persons specifically, Atli, Sardar, Jiabur and Noor Muhammad.
Hmm.
But again, in her cross-examination, she said that she had different statement. Police again said that Jiabur and Noor Muhammad she did not speak of. So we are left with only these 2 people. But then Lordship has to see again details. That's what is my.
All right, appeal or not, we can't say anything on that. That's for the state. This is not to say about this case. So many cases.
So many
yes, my lord. In some cases, my lord, sole eyewitness is sufficient to convict all the persons, my lord. It's not necessary there are too many witnesses record for eyewitness. If sole witness is reliable and trustworthy, then my lord, there is maybe conviction, the other accused also, my lord. So we have to go by the evidence, my lord, whether the sole eyewitness, how much he is reliable, or my lord, how he is trustworthy regarding the other co-accused, my lord. Because it was at night, 7 PM, the incident was happened. It was night. And after screaming, my lord, she went to the place of occurrence and She made her statements, he saw such and such and blow, and even the autopsy report also says, my lord, there is an injury of 9-10 injuries are there.
What more evidence is required to convict? What is the other evidence?
My lord, yes, that's why I'm saying is sole eyewitness is, my lord, they are trustworthy and reliable, then it's not, the other evidence is not necessary for conviction, the said accused persons. ma'am.
PW statement for
No, we'll see it, but we're keeping this matter pending.
My lord, yes.
On 6th January, we'll fix it. On
Lordship,
that date, SP will submit a report.
my lord,
If the accused is not apprehended,
my lord,
absconding accused, then we'll consider directing personal appearance of the SP.
my
We want
lord,
to see how the system is performing,
my lord.
whether the public should trust this system or not.
Of course, my
We
lord,
have
fine,
to
lord,
test
fine.
it. So merely writing letters here and there, this is not asking for customer service to repair a AquaGuard machine.
My lord.
People are murdered and they are absconding and the police is saying NBW has been using, we went to his house, didn't find him. Oh, you will wait in the
No,
house.
my
for
lord,
the
it's
police
not
to come.
sufficient. Simply go home
What
and
is the
searching him, my
response
lord.
to this? This inspector says, went to his house, I didn't find him there.
My
So
lord.
that's
It's
the
not
end of the
sufficient, my
matter.
lord. So I discussed with the SP
So
also, my lord.
pathetic then.
My lord.
Is this how the police acts?
My lord, absconder person cannot, my lord, sitting in his own home.
Oh,
my lord.
he will wait for him. You come, we'll serve you a cup of tea. Anyway,
My lord,
the matter will be posted again on 6th January. You
Lordship.
please use your good office. and-
my lord, yes, sir.
Otherwise, we'll summon the SP. He has to
Lord.
tell us
My lord,
what are the mechanism, what he has done. We'll ask him to file an affidavit.
lordship.
He better find that absconding person and that will be the stance adopted in most of the cases. In genuine case, there is no evidence, will definitely lead to acquittal, but
My
not in
lord.
this manner. Nobody is taking responsibility. Somebody is absconding. No one is trying to find out. And we have also found things in disarray for our house also.
My lord, yes, of course, my lord. We are also part of the
Very
same fighting,
casual
my lord.
approach of the district and session judge, particularly in this case. We'll see. Before making any further comment, we'll
Yes.
examine
Got you.
minutely. So that much for you.
Much obliged, lord. May I leave you, lordship? I have some another.
Yes.
Much obliged.
Yes,
Lordship will post it for on 6th or hear it today, Lordship.
on 6th. Take down. In terms of our order dated 10/12/2024, passed in the appeal, the public prosecutor, State of Assam, Mr. M. Fukan has appeared and produced a report from the Superintendent of Police, Ojai, to submit that after the order of this court was passed, efforts are on to rearrest the absconding accused, but no significant break, BREAK, has been made by the police in that regard till today. Mr. Fukan has also produced a copy of the notification dated 29/11/2022, issued by the Principal Secretary to the Government of Assam, Home and Political Department, laying down an SOP for monitoring judgments passed by the trial courts in criminal cases with provisions for referring appeal against acquittal and/or inappropriate sentences being awarded despite conviction, in a time-bound manner to submit that prior to the year 2022, the government has found that there were serious lacuna in the manner in which the state machinery was functioning in these matters. However, the system has now been revamped and at present, all the stakeholders are working in tandem to ensure that the criminal justice system remains efficient and effective. Full stop. Mr. Fukan has submitted that since the issuance of the notification dated 29/11/2022, the rate of filing of charge sheet as well as conviction has increased substantially. And with the appointment of the Director of Prosecution, the situation is expected to improve even further. Full stop. After hearing the submissions of Mr. Fukan, we are satisfied that the state has taken significant steps to ensure that the criminal justice system in the state delivers to its desired potential. However, insofar as the activities of the Hojai police is concerned, with regard to rearrest of the absconding accused, namely, what is his name?
Abdul Muttalib.
Abdul Muttalib. We are of the view that not enough has been done by the police to secure the custody of these accused. Full stop. Be that as it may, this matter is directed to be listed again on 6/1/2025, on which date the learned PP Assam will submit a fresh status report as to the action taken in the matter by the police in the meantime. Full stop. We make it clear that if the report is not found to be satisfactory, this court will consider directing personal appearance of the concerned SP with the relevant records. Full stop. A copy of this order be furnished to Ms. Jahan. Other things we'll see on that day, not on 6th.
July.
I think so.
Yes, I see.
So one thing is these appeals now. 2, 3 days,
No, even they have.
what
problem.
happens is these matters will not be kept part heard.
Yeah, right.
So you can start, but then you have to again start
No,
before.
they have also problem because B. Punya was in charge of this case last time. Actually, this was heard earlier by this.
By another bench.
Yes, ma'am.
No, there are some part heard matters. We had heard some appeals. These are not listed today.
No, part-heard matters, yesterday there was one, it was over, today it is one. Tomorrow there is one, bail matter, which is partly heard. Today there is none.
We wanted to deliver the judgments before vacation in the cases we have
But
already.
this will take some time, my lord, because there are many eyewitnesses and all.
Today there is no part-heard matter as such.
So after vacation,
Yeah.
after BU vacation, Mr. Z.
So we can prepare more in the vacation.
Because there is no clarity on whether this bench will continue. in
Right.
January. And what happens is then this part heard, you make it part heard, it gets stuck up.
Yes, for a long time.
This is bad for the client
Not.
who are in
That's true.
jail. Mr. Z. Kamal and senior counsel assisted by so-and-so appearing for the appellant. Also heard Ms. S. PP Assam appearing for the state who submits that the concerned APP with handling the brief is on leave and therefore the matter be taken up after the winter vacation. Full stop. Mr. Kamal and his senior counsel appearing for the appellant has submitted that in that case, this appeal be posted for hearing after the blue vacations in January 2025. Taking note of the submissions made by both the sides, registry director release this appeal accordingly. Yes.
But can it be listed on the 9th or
No, you said after BU.
thing?
Yes.
That will do, my lord. Much obliged.
Item 5.
Any case where we had heard a little bit, we would like to finish off. Instead of starting a new matter.
Here, my lord, only conversion, my lord, 5 witnesses, the rest are one injury, 10 accused, my lord.
There are 12 witnesses.
Only 5 were relevant because other statements were recorded 2-3 months subsequently. 161, my lord. So those are, my lord, and my lord, only the deceased, my lord, with all respect, my lord. Apparently, my lord, only fatal injury 1, my lord. Nothing attributed specifically to anyone. And my lord, why it's a case of conversion, my lord? Can I just, as I have understood, my lord, with all respect, my lord, may I just state it, place it before your lordship? Thereafter I read, my lord, with all respect, my lord. My lord, no weapons were carried at the time of occurrence, at the place of occurrence, my lord. There is no pre-plan or premeditation, my lord. Exactly at the spur of the moment it occurred, my lord. And weapons not deadly, my lord, only branches of trees, my lord. That too, those were gathered at the place of occurrence, at the time of occurrence, my lord, not carried from before, my lord. One injury, my lord, and that death occurred, my lord, because of non-providing medical treatment, possibly, my lord. These are the reasons, my lord, why we say that it's a case of conversion, my lord. With all respect, my lord. 10 accused persons. My lord, may I just begin from an opposite end, my lord, from the judgment. It is apparent, my lord, that it's a case of possibly a conversion, my lord. Page 157, my lord. I read 2 paragraphs, my lord, with all respect and full adherence, my lord, 70 and 71, my lord.
Yes.
70, my lord. May I, my lord? The
Yes.
medical evidence clearly shows that injuries were caused by blunt weapon. Therefore, it fortifies the contention of the prosecution witness from PW1 to PW8. 71, para. On the other hand, as contended by the learned defense counsel, non-examination of independent witnesses by the prosecution will not make any dent in the prosecution version. Because once a witness has been examined, his evidentiary value has to be considered in accordance with law. As per section 134 of the Evidence Act, and the quality of evidence matters, not the quantity of witness. In the present case, the evidence of PW1 to PW8 fully corroborate the evidence of PW9, Dr. Dinesh Chandra Sharma, that medical evidence, my lord. This line is very important, my lord. It is not a cold-blooded murder where there was no eyewitness. So it is not cold-blooded, my lord, whatever be it, my lord. And thereafter, I read the paragraph, my lord. The incident occurred within the locality when the deceased Hazrat Ali refused to bring China to his son Rahim as his daughter-in-law because of her darkness of color. This is the language, my lord, and ugliness. But the accused party became furious in the meeting and attacked deceased by forming an unlawful assembly with their common object equipped with wooden stick and bamboo lathi on his way back home in front of the house of Aziz. An entire altercation, my lord, was regarding solemnization of the marriage.
We'll call you.
Solemnization of the marriage, my lord, which unfortunately did not take place, my lord. Well, and my lord, now they are married, my lord. Now they are living as husband and wife, my lord.
After the incident.
After the incident. Now they are living as husband and wife, my
So
lord.
let us see the Ejahar once.
Yes, place 3, my lord. Page 3, my lord. It is lodged by PW1, my lord. Mutiar Rahman. Thereafter, my lord, there are in the accused persons, my lord, the 8 persons are named, my lord. 4 are not named, my lord. And my lord, it is in evidence, my lord. Definitely, I'll read it subsequently, my lord. After discussion, the names were inserted, my lord. I have the honor to state that at 7:38 on 8/1/2009, the accused person mentioned above, equipped with lathi, etc., waylaid my uncle Hazrat Ali in front of the house of accused number 1 and inflicted severe injury to him by assaulting him on head with bamboo lathi. Though he was immediately admitted to Borpeta Road Life Care Nursing Home, doctors referred him to Borpeta Civil Hospital since his injury was grievous one and He died at about 12:30 on so and so while undergoing treatment at Borpeta Civil Hospital. This is the case, my lord. But my lord, medical evidence, my lord, with all respect, my lord, he says, my lord, this was never admitted to Borpeta Civil Hospital, my lord. So where he died, where he was treated, those are not in evidence, my lord. With all respect, my lord. May I come to PW1, my lord? Page 10, my lord. He is not an eyewitness to the occurrence, my lord. Should I read or I shouldn't, my lord? This is apparent in cross-examination, my lord. I saw the incident, I'm reading the cross-examination first line, my lord, with all respect, my lord. I saw the incident myself. I did not see Hazrat being assaulted. Have I made my position clear, my lord? He is not an ocular witness, my lord. But that it began because of that settlement of marriage that could not, my lord, that formality could not be fulfilled. Then, so I read the first paragraph of Chief, my lord. I know the accused persons. I am the informant in this case. This is Hazrat Ali was my uncle. The incident took place about 5 years back. The day Hazrat Ali's son Rahim was talking to his daughter of Arfan of the same village in front of his house. It was around 7-8 p.m. Having seen Rahim talking to the girl, the nearby people asked him why he was talking to the girl and arranged the mail regarding this. In this mail, it was decided that marriage between Rahim and San Khatun, the daughter of Arfan, would be solemnized. In the mail, I was told that to call a Kaji. I was going to call a Kaji. After I had crossed some distance, I heard a hue and cry near a banana garden. Approaching there, I saw the accused persons running with lathi, branches of trees, etc. in their hands, and Hazrat lying on the ground nearby. I saw injuries on the head and eyes of Hazrat. It was bleeding profusely from the injuries of Hazrat. Having seen Hazrat lying unconscious on the ground, I sent him to Kalgasia PHE. But therefrom he was referred to Borpeta Road PHE. Since his injuries were grievous ones, he was shifted to Borpeta Civil Hospital. From Borpeta Road PHC, but he died on so and so on the same day. At about 2 p.m. on the following day of the incident, Hazrat died. I was present when inquest of the body of Hazrat was held. I lost an Adahar with PS in connection with the incident. Exhibit 1 is the Adahar so and so is my signature so and so, my signature. When Hazrat was lying at the place of occurrence, Ali Akbar, Khalek, Joynal, Jagir were present there. Aziz, Hussein, Hassan, Habel, Saifullah, Mullah, Hasibur, Rustam, Ansar, Luku, etc. committed the incident. The accused persons had bamboo stick and branches of trees on their hands. On getting the information of the incident, many people gathered at the occurrence. I do not know all of them. After lodging of the Azahar, police investigated the matter and questioned me with regard to the incident. Thereafter, my lordship may kindly have a look at page 13.
Yes.
Page 13, my lord, with all respect, my lord. I did the entire page, my lord. Said 2 accused persons were situated at about 2 kilometers away from the place of occurrence. Bakuria outpost is about 6 kilometers away from the place of occurrence. I do not know if Rahim lost the Adahar in connection with this case about 3 months later. This is important, my lord. I questioned Rahim's mother at a time of lodging the FIR. I discussed the matter with Mohidul Islam and Tota Master. Mohidul Islam is PW4. Meaning thereby, the FIR was lodged after due discussion where names may have been inserted, my lord. No one except Hazrat was assaulted at the place of occurrence. Only Hazrat was assaulted, the deceased, my lord. The other BBW say that they were also injured, my lord, with Mohidul Islam and Tota Master. No one except Hazrat was assaulted at the place of occurrence. While discussing the matter with the president of village Panchayat, he did not allow me to lodge the Adahar on the day of occurrence. Asked me to lodge the Adahar later. So afterthoughts are there in the Adahar. With all respect, my lord. Thereafter, my lord, my lord, cross-examination, my lord. Page 14, my lord. Further cross, my lord, with all respect, my lord. Leaving aside, my lord, from 8th line, my lord. Then I saw Rahim was kept confined in the Rahim means, my lord, the boy to whom the girl was about to be married, my lord.
You're reading in which page?
Page 14, my lord.
Yes.
Page 14, my lord, leaving aside 1, 2, 3, 4, 5, 6, 7th line, my lord. Leaving aside 6th line from the top, my lord. Then I saw Rohim kept confined in the house of Arpan. He is also a witness, and he is the boy who is married to the deceased, my lord, deceased daughter, my lord. Now, then I saw Rohim was kept confined in the house of Arfan. The residence of Aziz is not adjacent to others, and there is no other residence. With the house of Arfan and Aziz, Rahim was kept confined behind the house of Arfan. Then, in order to rescue Rohim, his father, brother, and other relatives went there, meaning that by the accused persons, Khalek, Motiur, so and so, all names, my lord, to the meeting and called to settle the matter. My lord, prosecution side went to rescue Rohim, my lord. Khalek, Motiur, Islam, so and so went to the meeting and called to settle the matter between Saina and Rohim, now husband and wife, my lord. Abdul Rahim, son of Abdul Khalek, filed another case against the above mentioned accused, alleging assault to Abdul Aziz Hussein Ali. In that case, Ayab was also made an accused by him. I do not know who are the injured in the case. I know that Abdul Aziz and Hussein Ali visited the doctor for the injuries. Abdul Aziz is appellant number 3, my lord. Hussein Ali is appellant number 4, my lord. I was also made an accused by him. I do not know who were the injured persons in the case. I know that Abdul Aziz and Hussein Ali visited the doctor for the injuries. At the time of incident, around 20 persons gathered there. The case filed by Abdul Rahim against us is pending in the Court of Sessions 372/15. My lord, cross cases are there, my lord. With all respect, my lord, that is still pending. Abdul Rahim, who did lodge the cross case, he happens to be the brother of appellant number 3 and appellant number 1, my lord. And 3 and 1 are injured, my lord. 3 and 1, they happen to be injured allegedly, my lord. Now I come to, my lord, with all respect, my lord, page 15. Page 15, my lord. He is PW2, my lord. I know the complainant. I knew this is Hazrat Ali so and so, so and so. I was at home. I heard a hue and cry at Arfan's house, situated 3 bighas of land away from my house. I proceeded towards the place of occurrence. I saw the accused persons, many other persons, including these are names, my lord. I saw exchange of words between the accused persons and these persons. In a bichar, extrajudicial settlement, it was decided that Rohim, son of deceased Hazrat, should marry Sania, daughter of Arfan. That day, a Bisar was arranged regarding this matter in front of the house of Arfan. In the Bisar, Rohim was found innocent, and therefore, while we were coming towards the respective houses, the accused persons waylaid us in front of the house of Robi and Aziz. At that time, Hazrat Ali was also with us. The accused persons assaulted us. I sustained injuries on my hand and back, and they assaulted me with bamboo lathi and branches of kendu kuna tree. Aziz, Hussein, so these are all names, my lord, assaulted Hazrat Ali indiscriminately with branches of kendu kuna tree and bamboo lathi. As a result, Hazrat sustained injuries on his head, his neck and ribs got broken, and one of his eyes bulged out, contrary to medical evidence. Accused Aziz Hasizuru declared Hazrat dead, caught Hazrat's son Rahim and took him away with other accused persons. Then from the place of occurrence, we took injured Aziz to his home and therefrom to Kalgatia hospital. Meaning thereby, when he was taken home, my lord, normally human tendency, my lord, the one is grievously injured, my lord, profusely bleeding or whatever, he would have been taken to straight away to hospital, my lord. He was taken home, and this hospital records are nowhere exhibited, my lord. Possibly he was never taken to hospital, and doctor has opined, that I'll come later, my lord, that he was never admitted to Borpeta Civil Hospital, my lord, Kalgatia Hospital. From there, he was referred to Borpeta Road Life Care Nursing Home, and the next day he was shifted to Borpeta Civil Hospital. Nowhere on record, my lord. And the day itself, Hazrat died in the hospital at about 12:30 o'clock, my lord. This, my lord. And thereafter, my lord, Lordship, kindly have a look, my lord. Para 17, my lord. Page 17, my lord. This is very important, my lord. Leaving aside, my lord, in between, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 16th line, my lord, in between, my lord. All the accused persons had bamboo lathi and branches of kendukuna tree in their hands. The most important part is, my lord, when the accused persons were present in the male, there was no bamboo lathi or branches of kendukuna tree in their hands. To this effect, several witnesses have deposed, my lord, meaning thereby they had no plan, no premeditation, they never carried any weapons, not even lathis, my lord. And lathis are, my lord, with all respect possibly, lathi would not be the right time, that kendukuna tree branches would be the right time, because in village, that tree is very prevalent, my lord. With all respect, my lord. The accused, this is, I'm sorry. He is also an accused in the cross case that occurs at page 20, my lord. Page 20, my lord, leaving aside
Yes.
5 lines from the top, my lord, I leave aside. Rohim son of Abdul Khalek filed a case against us, alleging assault, which was registered as Sessions case number 375/15, exactly as has been stated by PW1, my lord, pending in the court. I do not know how Hussein and Aziz sustained injuries. I also do not know whether they took treatment. It is not a fact that Abdul Khalek so-and-so, 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 Aziz and Hussein, the incident of assault took place after I left for my residence. This is not important, my lord. Thereafter, my lord, PW3, leaving aside 5 lines, same, my lord. In that mail, it was said that there had been love affair between Rohim and Saina, and they should get married to each other. But at the end of mail, it was found that there was no relationship between them, and the accusation was false. In the mail, as his son was proved innocent, Hazrat did not give consent for the marriage. As Hazrat Ali did not give consent for the marriage, Saina's uncle Anwar Ali got angry, and the male and then Hazrat Ali left the bichar. Thereafter, when the Hazrat reached in front of the house of Azizur, accused Ansar Ali ordered other accused so-and-so, so-and-so, so-and-so to assault Hazrat. Thereafter, my lord, with all respect, leaving aside some lines, my lord, after the my lord, leaving aside 5 lines, my lord, with all respect, I should have read it the entirety, my lord, in entirety. After the incident, the injured was taken to Kolgosia by a vehicle, but therefrom he was referred to Borpeta Life Care Nursing Home on the night itself. At about 10 p.m. on the following day, the
10
injured person.
10 a.m.
Or 10, I'm sorry, my lord. I'm sorry, my lord.
Yes.
10 a.m. to 10 a.m. on the following day, the injured person was taken to Borpeta Civil Hospital, meaning thereby the death may have occurred because of the delay in treatment, my lord. That I have said initially, my lord, hospital. But injured Hazrat died at Borpeta Civil Hospital. This is very important, my lord, at Borpeta Civil Hospital, my lord. Thereafter, my lord, again, my lord, that lathi was not carried from before, my lord. That occurs at page 23. My lord, reading between the lines, my lord. Even line. 12th line, my lord. During the hue and cry, other people present in the mail went away. There was no lathi in the hands of the accused persons when they were present in the mail. Meaning thereby, my lord, that intention to kill was not there, my lord. Definitely, they did not carry any weapons, my lord. Apparent on face of the record, 2 witnesses were ocular witnesses, my lord. With all respect, my lord. Thereafter, I turn the page, my lord. They are all accused in the cross case, my lord. Now, PW4, my lord. He is the person to whom PW1 talked to, as he has mentioned earlier, my lord, before lodging the FIR, my lord. I know the accused persons and the informant. This is Hazrat Ali was my father. The occurrence took place on 8/1/2009 at about 7:30 p.m. Following the order of accused Ansar Bhuiya, the other accused persons took my brother Abdul Rohim from the road to the house of Arfan, brother of accused Ansar. the accused person intended to get my brother Abdul Rahim married to Arfan's daughter Saina forcefully. My brother refused to marry Arfan's daughter because her complexion was dark and she was not good looking. Thereafter, my lord, if I continue, my lord, with all respect, my lord, leaving aside 2 lines, but accused persons intended to get their marriage solemnized forcefully, alleging that my brother had a love affair with Arfan's daughter Saina. Thereafter, my lord, in piece 27, my lord, seventh line, my lord. Having learned this, my father asked the accused persons why they were forcing to get the marriage solemnized, and when he intended to come back to the house after expressing his disagreement for the marriage between Abdul Rahim and Saina, accused answer exhorted the other accused persons to assault my father. My father had already left Arfan's house, and when he reached the front of the house of Abdul Aziz, accused answer hit my father on neck with a bamboo lathi. When he fell down on the ground, immediately the rest of the accused persons assaulted him with branches lathi of Kendukuna tree. Thereafter, my lord, leaving aside some lines, my lord, that hospital part, my lord, due to assault, my father sustained injury on his entire body, contrary to medical evidence, my lord, including head, he bled. When my father took him to Kolgosia Hospital, therefrom we took him to Life Care Nursing Home at Borpeta Road, and thereafter to Borpeta Road CHC. Though he stayed there for a day, at about 12 a.m. in the night, the day itself, my father died in the hospital. Here it is said not to Medical College Hospital, my lord. In some hospital to that effect, my lord, regarding hospital and no record as such. Why I am saying, my lord, had there been proper treatment, there may not have been death, my lord. With all respect, my lord. Thereafter, my lord, next witness, my lord. All same, my lord. Exactly tailor-made, my lord. Tailor-made, my lord. Thereafter, my lord, I am reading PW 5, my lord. PW 5, page 31, my lord. Page 31, my lord. This is also regarding a Bisar, my lord. Same
So
exactly,
is
my
there
lord.
eyewitness to the occurrence? No.
They are claiming all.
All 1 to 5, no.
Good, good,
All to, one, of course, in one vague statement, he said, I did not see the incident. But others were all there. When they came out of the mill, and others, there were so many people there. And so others have seen them beating with, of course, branches of tree and all those. Of course, the case can come within sudden grave and sudden provocation.
My lord, eyewitnesses are, as he is correct, my lord, the language and tenor, my lord, as if they were present. But in such omnibus manner, my lord, without attributing anything. And my lord, all these, my lord, after discussion, affair was lost. Why I am saying, my lord, if we visualize a situation, my lord, certain, my lord, with all respect, my lord, that definitely, my lord, ingredients have been incorporated. That is apparent, my lord. All cannot say the same thing, my
So
lord.
how many accused persons have been convicted here?
All 10, my lord.
They are all in jail,
All in jail, my lord.
presently in jail.
Presently in jail.
For the past 5 years.
For the past 5 years, 5 months, my lord.
No,
And my lord,
some witnesses have said 8 of them. Some had named 9.
well,
Those
may I
things are
read the
there.
doctor, my lord? It would be apparent, my lord. May I just read the doctor once, my lord? Can I just read PW 5? That, my lord, that Marpit took place, my lord, at a spur of the moment, apparent on reading, page.
So you want that there should be conversion to 304 part 2.
We are definitely, my lord, there are authorities regarding 320. That I leave it to your lordship.
Or 323.
320, no, 23 it cannot be, my lord. It has to be 325 possibly.
325.
Or anyway,
Head injury.
but 10 people, nothing attributed, 1 injury head, my lord. Can all be roped in, my lord.
And this is with the assistance of 149.
Exactly, my lord.
Common object.
What is the common object?
Yes.
Because he did not agree to the marriage. they
Common
wanted
object
to
was to beat him up,
beat him up.
not to kill
But
him.
head.
Assuming there was common object.
Common object can be at the spur of the
You
moment.
please think about it. We'll have some questions to answer.
Lordship.
See, to assume a common, one can understand if they are all members of the same family
Hmm.
and they are enraged because some derogatory or insulting gesture has been shown towards the lady.
Hmm.
One can understand they being enraged. But those who are not a part of the family, the fact that they had a common object, that has to be established by the prosecution. It has to be established and there has to be a finding.
Hmm.
Otherwise, how many injuries? One injury.
Fatal injury, one, my lord.
Frontal and the temporal both.
On
is
the hot
fractured.
frontal region, my lord. Frontal and parietal, my
Parietal
lord.
region.
So how many fatal injuries?
Single.
One. Lordship will see the
My lord, can I
PW9.
just read this paragraph? And
PW9, yes. Okay.
I'm sorry, my
Hmm.
lord. Lost to the
Ms. Jahan, what we are asking you is simple.
Yes.
This is the conviction with the assistance of 149. So as you have mentioned, and that's the law, there has to be common object.
Hmm.
It has to be an unlawful assembly.
There
and
has
it
to
has
be.
to have a common object.
Hmm.
So both these things will have to be proved in this case
Mm.
because these 10 accused persons, there is nothing to suggest that they flock together for any particular purpose.
No, there was a Mel. They flocked together because
Oh, Mel was what? For a Bichar.
Bichar.
After the Bichar didn't work out,
Haan.
to show that these 10 had ganged up with the object to hit him and
Hmm.
commit his murder, there has to be evidence and there has to be a finding of the trial court.
Hmm.
This can't be presumed.
This can't be presumed. And that has to be seen
Because
from the.
we are saying that even this was possible if, let's assume that there is no evidence, then also if all of them were, say, brothers
Hmm.
belonging to the same family
Hmm.
and they are enraged because some derogatory comments, remarks, or something said to the lady, saying that she is dark or ugly or whatever, that could be the ground to be enraged. But for people who are not connected with the family,
Hmm.
there can't be a presumption that they were enraged. So if they were not enraged, where is the question of common object unless there is evidence to bring on record and to prove it?
Hmm. Now, common.
And if there is no common object,
Then these
and
people
if there
cannot-
is no specific evidence to implicate any one of them,
Hmm.
this will be a case of acquittal.
Acquittal, yes, in that case. But common object, Lordship knows it has to be deduced from the facts of the case. Now here, all the witnesses have stated that
So you
when
look
the
into it and address
Lordship.
the court.
Lordship, after he
Because,
finishes.
because yes, we are just putting you in on notice.
Lordship.
Appellant 1, 3.
So you are arguing for conversion and we are saying this could be a case of acquittal, Mr. Mahajan.
No, initially, my lord, I thought because of paucity of time, my lord, definitely that will be in the base course of action. But my lord, otherwise, 5 years nobody is working, my
Then
lord.
we'll follow your suggestion.
As I feel, my lord, because 5.5 years inside, my lord. With all respect, my lord. Now, my lord, may I read one witness, my lord, that would absolutely crystal clear, my lord, that it occurred at the spur of the moment, my lord. It occurred at the spur of the moment, my lord. With all respect, my lord.
Just a minute.
It-
You understood what I'm saying? This is obviously 10 people convicted, all of them are not. Indian. Obviously, at the most 2 persons killed. And we are now, which are these 2 people? No evidence to. They were in a assembly. Now, if they are in a assembly, then we can bring in one body. Point is, bring in one body. You have with evidence. They are in a, and because when people were together, we 10, somebody said, one is, bring all of them in. Has to be evidence that X, Y, Z, W, P, they had these common. Was they wanted it is right. Now, if the prosecution case is that was arbitrary works were made about Villagers, we enrich them. The family members again. Somebody else. I think it is murder. I can't presume. Yes or no? The evidence is what he has done, what his activity. Better. Yes.
My lord, with all respect, my lord, that it occurred at the spur of the moment. Page 34, my lord, PW5. Cross. Page 34, my lord. May.
Yes, please.
I went to attend, I read the whole page, my lord, to police that accused Saiful and Hazrat were there during the occurrence. I went to attend the mail that day. I went with Hazrat and others. I did not know it earlier that there would be a fight in the mail. When there was exchange of words in the mail, people got divided into two groups, exactly at the spur of the moment, my lord. We took Hazrat to his home in an injured condition. This, my lord, clears all doubt, my lord, at the spur of the moment, and he was not taken to hospital, my lord. And thereafter, my lord, the next page, my lord, with all respect, my lord, cross-examination, my lord. At the time of incident, I was present in the masjid, and there was around 100 people present there. The place of occurrence is about distance of 1 kilometer from masjid. Hearing about the incident, I went to the place of occurrence. I saw the quarrel and saw a gathering around 20-25 persons. The accused person assaulted our persons and also filed a cross case against us, alleging assault on Abdul Aziz and Hussein, my lord. He claims to be an eyewitness, my lord. He was at the masjid, my lord. And raised witnesses I am not reading because, my lord, PW6 occurrence is on 8/1/2009. His 161 was recorded on 7/2/2009, my lord. Thereafter, all in the similar, my lord, the learned session just put reliance on this in this witnesses evidence, my lord. PW7 same, my lord. There are also 1.5 months delay, my lord.
PW8 is the boy.
PW8 is the boy. He once 61 statement was recorded on 31/3/2009. So possibly, my lord, of no relevance much, my lord. Which only thing that they were married, it can be shown apparent, my lord. They are married to each other, my lord. Thereafter, I am reading the doctor's evidence, my lord. With all respect, my lord. It is cryptic, my lord. I'll read it, my lord, with all respect, my lord. Page 47, it occurs, my lord. On 10/1/2009, I was working Borpeta Civil Hospital as SDM and HO, health officer. On that day, in connection with Baikuri PA General entry number so and so, I performed the post-mortem examination on dead body of Hazrat Ali. On external appearance, a male body not decomposed, rigor mortis present, body looked pale, blood stains seen all over his clothes, no facial or seminal discharge is seen, swelling present over right parietal region along with right cheek, eyeball looks black, multiple abrasion noted over cheek and both legs. Spinal disorder, my lord, scalp, externally scalp look healthy, large amount of blood clots seen below the scalp, both frontal and parietal bone on right side are fractured. This is fatal, my lord, one injury. Both frontal and parietal bone on right side are fractured, membrane lacerated on right side, large amount of blood clots seen over the brain, lacerated brain, no other injuries. the injuries mentioned about the antemortem in nature with antemortem blood clots seen in and around the injured tissues. In my opinion, death is due to shock and hemorrhage following head injury caused by blunt object. Time since death is about cross-examination. Such type of injuries may be caused due to falling hardly on hard substance with force. I have not mentioned any PS case in so and so. Thereafter, my lord, leaving aside two, I have not provided medical treatment. I cannot say whether injured was treated medically. I cannot say when the person was dead specifically. The person was not admitted in civil hospital Borpeta. Must have been from records, my lord. Thereafter, my lord. Last line, my lord. It is not a fact that the injured took treatment at Borpeta Civil Hospital. Had he been provided, because there are authorities to that effect, Lordship's authority, my lord, that had there been medical treatment, he may not have expired, my lord. At the 49, my lord, one line is there, my lord, at the top, my lord, with all respect, my lord. That is bad, my lord. If proper treatment was provided, the person could not survive for long time, but remained alive for few hours. That also I have read out, my lord.
Yes, all right.
Thereafter, my lord, with all respect, my lord.
Hmm.
Should I place, my lord, in similarly situated? My lord, in the judgment, my lord, at 149 part finding, my lord, can I just read it out,
Yes,
my
sir.
lord? Paragraph 67, my lord.
Page,
Page, my lord, 156. May
yes,
the evidence of prosecution witnesses made it crystal clear that all the accused persons present on the spot and assaulted Hazrat Ali with bamboo lathi and branches of kendukuna tree by forming an unlawful assembly equipped with lathi, deadly weapon, almost nearby the house of Arfan Ali, in front of the house of Abdul Aziz, causing serious head injuries. Therefore, the acts of the accused clearly fall under the definition of section 147, 148, read with section 149 IPC, and they formed a group of more than 5 persons and attacked Hazrat Ali immediately by restraining in front of the house of Aziz, and after he was coming out from the meeting in the house of Arfan Ali. As it appears from the evidence of witnesses, all accused participated in the offense. So their common intention was writ large. As such, it is immaterial who assaulted Hazrat Ali. There was overtake on the part of each of the accused persons. The action of accused persons also attracts the offense under section 341 IPC, as they restrained Hazrat Ali near the house of Aziz while returning from the meeting. Accused persons from the unlawful assembly immediately after Hazrat Ali disagreed in the marriage of Saina with son Rahim and came out of the meeting as the accused side wanted to marry Saina and Rahim by force. Therefore, their feeling aggrieved, assaulted Hazrat Ali, equipped bamboo lathi and branch of kendukuna tree, and gave fatal blow on the head of Hazrat Ali. Here is the only thing, my lord, fatal blow on the head of Hazrat Ali by who? It is nowhere in evidence, my lord. Thank you. I could make it.
Yes.
But no blood was found.
Branches of trees were
Seized and sent to this one. Okay.
negative, negative.
So we don't want to be technical, but there is no ground in the appeal that common object has not been proved. That ground has not been taken.
My lord, my lord.
All right.
My lord,
All right,
see,
all right.
close up here. My lord, another aspect, my lord, to be very honest, my lord, that head injury part, that fatal injury, my lord, it has been attributed to, now it has been told to me, my lord. One appellant, can I just read that, my lord?
Yes.
PW4, page 20.
PW4, page 27, my lord. My lord, leaving a exact line I am quoting, my lord. 12th line, my lord. Answer hit my father on neck with a bamboo lathi, and when he fell down to the ground, it is attributed to, my lord, appellant number 9, my lord. Answer hit my father on neck with a bamboo lathi, and when he fell down to the ground. Immediately, the rest of the accused persons assaulted him with branches of lathi and kendukona tree.
So his 164 statement was also recorded. PW4,
PW4, my lord. Yes, yes, my lord.
is there any contradiction In his version PW4,
It is there, my lord. I'll take a minute. Huh? Page 167, my lord. তুলে দিই। May
yes, please.
At about 9 p.m. on the day of Moharram, about 8.5 months back, when Abdul Khalek, these are all names, my look, Rahim, my father and I were coming back to house after offering namaz in masjid. Abdul Aziz, Abdul Rahim, Hussain Ali, all appellants are named, my look. Then I assaulted my father Hazrat with branches of Kendukuna tree and bamboo lathi in front of the house of Robi and Aziz. The accused person assaulted my father because my brother Rakim refused to marry Arfan's daughter. My father Hazrat said got fractured. He sustained injury on his eyes also. We took him to the house. Due to the assault, my father became senseless. My uncle Abdul Khalek, maternal uncle Juran Ali, took my father to hospital. My father died in Borpeta Civil Hospital in the following night. Yet answer has not been specified by it. Right question. Eh? No, whatever we answer naam to koane bhaato. Oh, nai koi. Eh? This contradiction has been put before the IO, my lord. This was the fact that I stated either to police that when my father disabled, or night communication. Answer is many bit probably. $29. It took you. $54. $54 mungkin tes. Oh, nice. Listen. Same incident. That should have been tied together. You see. Subsequently acquitted, my lord. Acquitted, my lord. Sure to.
Police has said there is a cross case in it. And cross case has to be heard one after the other, not together. So it was heard
In tandem together.
one after the other evidence. Then
Yeah. Yes, ma'am, you are correct.
you know, if Abdul Khalek ko 164 আছে না? না না না।
এইটো কিমান পেজত আছে? Page 54 ন? Page 54 কোনটো আছে? 54 আৰু সাজেশনটো Can I, my lord, that it was contradicted, contradiction was also proved, my lord. Can I just place it, my lord, that hitting part? My lord, with all respect, my lord, that occurs at page, suggestion is at page 29, my lord. May I just read it, my lord? 20 line, leaving a key line, 11th line from bottom, my lord. From bottom, my lord. It is not a fact that I stated neither to police or the magistrate that when my father disagreed for the marriage in the mail, accused Anse exhorted the other accused persons to assault him. That Anse assaulted my father on nap by means of lathi. This is the suggestion, my lord. And the IO, my lord, that occurs at page 54, my lord. Page 54, my lord. Second line, my lord. When Mahidul Islam did not state to me, witness Mahidul Islam, PW4, no? PW4 did not state to me that in the night of occurrence, he and his father left the meeting. I'm sorry, my lord. The one paragraph prior hand, my lord. He did not state to me that when his father Hazrat disagreed for the marriage, Ansar asked other persons to make assault, and then Ansar assaulted his father on neck. Page 54, my lord. Contradiction has been proved, my lord. Now, my lord, should I place some one or two authority of your words? My lord, one is on acquittal, my lord, in such circumstances. Can I just place it, my lord, or should me ignore it? 325, my lord. That also I am honest enough to place it before a lordship, my lord. But my lord, only thing, my lord. No, I'm not saying that, my lord. I have understood. I'm sorry, my lord. Something I should have said something else went out. What I'm meaning is this, my lord. Even in that event, my lord, on technical evidence, my lord, with all respect, my lord, whether ocular can be brushed aside, my possibly not. That is one part, my lord. And in such a given situation, my lord, of course, my lord, this authority, our High Court, my lord. I'm just reading the relevant lines and placing it before your lordships, my lord. That occurs in para 16, my lord, of this authority, my lord. 2018, SCC Online, Guwahati, page 352. 16.2. May I read, my lord? 16, my lord. From a conjoint reading of the evidence of the all aforesaid witnesses, it can easily be perceived that in that case, my lord, Khalil Ahmed was the person who made the assault on the head of timers with Lenja. There is hardly any reliable evidence to show that the appellants had assembled and were waiting for timers with common object to kill him. And when he reached the place of occurrence, they attacked him. Rather, it is the evidence that on the date of occurrence, the appellants dismantled some portion of the fence in the field. Timers, on coming to know about this, went to appellants to object. But the appellants abused timers, who reiterated his protest. At that point of time, Khalil Ahmed suddenly inflicted a blow on the head of timers with Lenja, that is spear, my lord, and timers fell down on the paddy field. The medical report shows corresponding fatal injury on the head of timers as inflicted by Khalil Ahmed and only 2 more simple injuries, that too on his non-vital parts. We have injuries on legs, my lord. Had the 6 appellants assaulted timers with lathis after he fell down helplessly, definitely there would have been multiple injuries on the dead body. But the absence of such injuries would go to show that the appellant did not assault him. Thereafter, my lord. Thereafter, my lord. Para 12, my lord. Para 17, my lord. The 7 lines leaving aside from the top, my lord. It was only injury number 1, which was serious and proved to be fatal, like in our case, my lord, that parietal lesion. Hence, the Supreme Court observed that although the ambit of section 149 IPC is wide in its sweep, but in fixing the membership of the unlawful assembly and in inferring the common object, various circumstances also have to be taken into consideration. Having regard to the omnibus allegation against the appellants, again, my lord, having regard to the omnibus allegation against the appellants, who did not cause the fatal head injury, the Supreme Court held that it was not safe to convict every one of them for the offense of murder by applying section 149 IPC, and a common object of unlawful assembly was only to cause grievous hurt. Assuming not admitting possibly the same scenario. And here, my lord, that fatal injury part, my lord, to whom it can be attributed, that is nowhere attributed. That is the best part of it so far as defense is concerned. My lord. And my lord, 2 or 3 of it, very limited. This is, of course, on conversion, my lord, with all respect, my lord. This is, my lord, 1992, my lord, with all respect, my lord. Here I am reading, my lord, with all respect, my lord, first page. Paragraph 2, my lord. This is Para 2, my lord. We have heard learned counsel for the parties. We agree with the High Court that the participation of the appellants in the occurrence, which resulted in the death of Jawahar, has been proved beyond doubt. We are, however, of the view that keeping in view the nature of injuries on the person of the deceased and the fact and circumstances of this case, the offense committed by the appellants comes within the mischief of section 325 read with 34 IPC. 13 external injuries were found on the dead body of Jawahar. Out of those, 11 were on the lower legs and arms. The High Court, while considering the nature of offense, observed as under. These accused and other associates who beset themselves on Jawahar could never have intended to cause the death of Jawahar, for if such was their intention, they could have certainly killed him, especially after carrying him to the Choliam field and left him dead there instead of merely causing simple and grievous injuries to him. Even with reference to the aspect whether the accused persons could have intended to cause such injuries as would be sufficient in the ordinary course of nature, the cause of death. Thereafter, I read, my lord, para 3. Agreeing with the above observations of the High Court, we are of the opinion that the intention of the appellants was to cause grievous injury, and as such, the offense committed by them comes within the parameters of section 325 IPC. We therefore set aside the conviction and sentence of the appellants under section 304 part 1 IPC, read with section 34 IPC, and instead convict them under section 325 IPC, read with section 34 IPC. Pardon. Another one, my lord, with all respect, my lord, 2002 GLT, page 198, Arun Turi, my lord. There it occurs, my lord, with all respect, paragraph 10, last 5 lines of paragraph 10 and para 11, my lord. Isn't it? It up to the answer. With all respect, my lord. Last 5 lines of para 10, my lord. From those deposition, it is patently clear that a prosecution failed to prove their case beyond reasonable doubt as regards the individual participation of the appellants. Very clear here, so same is the situation. In the assault and causing death to the deceased, it also did not come in the evidence of the respective witnesses about the definite role played by the appellants to make them liable for conviction under section 302 IPC. Para 11. It is also interesting to find that there is no evidence to show that from the date of assault, that is I 26/93, to his date, that is 23/6/93, where the deceased was kept, there is absolutely no evidence that during this period, the deceased was at Golaghat Civil Hospital under treatment. Same is the situation, my lord, 2 days in our case, where he was nowhere in evidence, my lord. That way also we may get some benefit, my lord. This was converted from 302, my lord, to 326, my lord. With all respect, my lord. Our object is blunt, my lord. This one is for 302 part 2, my lord. This is, my lord, Guwahati High Court, 2019 GLT, page 700. (29 or 32, no? Well, here I read the first part of para 29, first part of para 30, and para 32, my lord. On perusal of the testimonial of PW forensic, in that case, my lord, who were the eyewitnesses to the incident. It has emerged that when the Bihu function was going on, there occurred an altercation between the deceased, Bhaskar, and the accused persons prior to midnight inside the Bihu pandal, and at the intervention of some other persons, including the Bihu committee members. The parties were separated and the matter was stated to be resolved. Thereafter, at a time past midnight, the members of the comedy group started making preparation for their departure. Thereafter, my lord, para 30. As per the medical evidence, the deceased has received a contusion injury over the head situated at the backside place and lacerated injury over the right arm of the backside. The doctor opined that the injuries were consistent with a blunt force impact. The doctor has found depressed fracture at the backside of the skull. The assault was in the midnight, intervening 22/5/2005 and 23/5/2005, and the autopsy doctor examined the dead body of Bhaskar on 28/5/2005. Thereafter, para 32, my lord. It has emerged from the evidence on record that the injuries were not sustained by the deceased from any sharp weapon. The accused person has regrouped themselves after the previous altercation inside Bihu pandal and waited for the deceased to arrive at the place where the motorcycle was parked, but the accused person did not equip themselves in the meantime. We never came equipped, my lord, with any weapon while waiting there for the deceased, but they used only bricks, which might have been available at the spot. Exactly, Kendukona trees, my lord, prevalent there, my lord. It thus appears that the intention of the accused person was to teach the deceased elation for the previous altercation with them by giving him a beating by all of them together, and they might have the knowledge that such physical assault by bricks on the deceased by 4 of them together might result in such bodily injury which likely to cause death. It was converted from 302, 304 part 2, that is in para 34 parting lines, my lord, converted to rigorous imprisonment. And another one, my lord, with all respect, my lord, 2020, 9 SCC, page 520. There I read para 6, 7, and 8, my lord. Injury is, my lord, at the top, my lord, the post-mortem report. Sorry. Para 4, my lord, next page. Ma'am. The post-mortem report proved by the doctor on proper para 5, my lord. The post-mortem report proved by the doctor PW 13 found to contusions on the left and right parietal portion and fracture on the left parietal bone, opining it to be dangerous to life. Other injured witnesses have confirmed that the appellant also suffered injuries in the occurrence. Para 6. A lathi is a common item carried by a villager in this country, linked to his identity. The fact that it is also capable of being used as a weapon of assault does not make it a weapon of assault simpliciter. In case like the present, on an assault on the head with a lathi, it is always a question of fact, and each case where there was intention of to cause death or only knowledge that death was likely to occur. The circumstances, manner of assault, nature and number of injuries would all have to be considered cumulatively to decipher the intention or knowledge as the case may be. 10%, my lord, 1 fatal injury, my lord. Thereafter, my lord, suffices to notice that from precedents that in Joseph versus State of Kerala, the appellants dealt with 2 blows on the head of the deceased. The deceased died 2 days later, same is the case here. The post-mortem report found lacerated injury on the head and internal examination revealed fracture to the occipital bone extended up to the temporal bones. The High Court convicted the appellant under section 302 IPC, holding that the injury caused by the lathi was sufficient to cause death of the deceased. The court observed that this court observed as follows. My lord, 3 within my lord parenthesis, last 3 lines, my lord. We accordingly set aside the conviction of the appellant under section 302 IPC and the sentence of imprisonment for life awarded thereunder. Instead, we convict the appellant under section 304 part 2 IPC, sentencing him to 5 years RI. Para 7. The Samru versus State of MP, the appellant dealt a blow on the head of the deceased with a lathi, which proved fatal. The injury was medically opined sufficient in the ordinary course to cause death. Conviction under section 302 IPC followed. The court observed as follows. It now remains to consider whether the offense which he committed falls within the first part of or the second part of section 304 of the penal code. When the fatal injury was inflicted by the appellant on the head of the deceased, but only 1 blow, in our case 10% blow, given in the manner alleged by the prosecution, it could as well as be that act by which death was caused was not done with intention of causing death or causing such bodily injury as is likely to cause death. The act appears to have been done with the knowledge that it was likely to cause death, but without any intention to cause death, or or to cause such bodily injury as is likely to cause death within the meaning of Part 2 of Section 304 of the Indian Penal Code. Thereafter, my lord, with all respect, my lord, para 8, in Gurmukh Singh versus State of Haryana, the deceased died 3 days later after an assault on head with a lathi, opined to be sufficient in the ordinary course of nature to cause death, holding that assault was made on the spur of the moment, exactly spur of the moment, without premeditation, the conviction was altered from 1 under Section 302 to Section 304 Part 2 and sentence of 7 years was handed. This much, my lord. Date of judgment, my lord, with all respect, and the date is, my lord,
10/7/19.
10/7/19.
For 5 years, 5 months.
5 years, 5 months,
9 days.
9 days. And during investigation, that we do not know, my lord. My lord.
What I find in this case is that there are 7 numbers of eyewitnesses. And contradictions are also do not go to the root of the case. Lordship will find PW1. PW1 was sent by the accused party to bring the Qazi for the 1 to 7.
8 to
8 to 8 to 8 to no 8 I had seen it later. No 7 to order.
My lord, because he was the boy
8
to
is
whom
the yes
the
8.
lady was supposed to be given in marriage.
1 to 8. 1 to 8. Rahim, he is the Rahim. Number 1, PW1, Lordship will find that he was sent to bring the Qazi. And when he was going, he heard a hue and cry at the back. And then he turned and he saw the incident. He did not see who had assaulted Hajrat, but he saw the incident. So he turned back and he saw all these people carrying lathi, branches of tree, and the victim lying nearby. So he had seen the later part of this story, but then he had seen the accused persons present there. He had said, Lordship will find that page number 11, approaching there, I'll just read out. Approaching there, I saw the accused persons running with lathi, branches of tree, etc. in their hands and Hajrat lying nearby. Very first 3 lines at page number 11. So he had seen them with lathi and branches of tree. All the accused persons, all the 10 accused persons. Then little down below, Lordship will see 4 lines from the top before cross-examination. Aziz Hussain, Hassan, Habel, Saiful, Mullah, Hafizur, Rustam, Ansar, Luku, etc. committed the incident. So he said this. And he said in the cross-examination, I saw the incident. I did not see Hajrat being assaulted. He did not see. He saw Hajrat lying down on the road. Then Lordship will see PW and PW1, there is no contradiction. PW1, Lordship will find at page number 55, what the police said. The police said, Motiur Rahman stated to me, I did not see who assaulted my uncle. That is the only statement that the police said. And there is no contradiction as such because he said, who assaulted deceased, he did not see. There is no contradiction as far as PW1 is concerned. Then PW2. PW2, he said that he was there. Lordship will see at page number 15. He said, I proceeded towards the place of occurrence, saw the accused persons and many other persons, including Rahim, Abdul Khalek, Joynal Abedin, etc. I saw exchange of words between the accused person and these persons. Now, this shows the common object. Initially, there were exchange of words. I saw exchange of words between the accused person. In a bichar, it was decided that Rahim, son of deceased Hajrat, should marry Sania, daughter of Arfan. That day of bichar was arranged regarding the matter in front of the house of Arfan. In the bichar, Rahim was found innocent and therefore while we were coming towards our respective houses, the accused person waylaid us. This shows that the accused person chased them. While we were coming towards our respective houses, the accused person waylaid us in front of the house of Robi and Aziz. At that time, Hazrat Ali was also with us. Accused person assaulted us. I sustained injury. So this shows that they had chased them after they came back from the house of the girl's father. Then Lordship will skip 2-3 lines and then Lordship will see the accused persons. No, continuation will do. I sustained injuries on my hands and back and they assaulted me with bamboo lathi, kendukuna tree. Aziz, Hussain, Hassan, Abel, Hafizur, Ansar, Rauf, Saiful Mullah, Rustam Ali, etc. Among the accused person assaulted Hazrat indiscriminately with branches of kendukuna tree and bamboo leaves. And as a result, Hazrat sustained injury on his head. His neck, ribs got broken and one of his eyes bulged out. Lordship will see, then the Lordship will see the cross-examination. Again, he reiterated that the accused persons had followed them. In the cross-examination, Lordship will see at page number 17, 7th line from the top. The accused persons, Lordship got it, 7th line, yes. The accused persons present in the dock today were present in that mill. While we, Hazrat, Khalek, Mofizul, etc. and I were coming together from the mill, the accused persons followed us. It was not a fact that accused person kept sitting in the mill itself and that the mill was going on. It is not a fact that accused person did not assault us. So he reiterated, they followed and assaulted. Lordship will see go to the police's statement. What are the statements that he contradicted? PW number 2. Lordship will go to page 55. The last paragraph. This is in respect of PW number 2, Ali Akbar. Last paragraph at page number 55. Lordship got it? Witness Ali Akbar stated to me that police caught Saina Khatun, people caught Saina Khatun and Rahim, held a bichar and adopted a decision to get them married with each other. Stated to me, no contradiction. Ali Akbar's statement was recorded in so-and-so. Lordship had seen 164 statement where he had corroborated. Of course, he corroborated in a little different way. He did not say about the male. He said about coming back from the namaz when the incident took place. But it does not go to the root. These are the people who had assaulted the deceased and the others. There is no contradiction. Ali Akbar did not state to me that, witness Ali Akbar did not state to me that police took lathi and lathi made of branch tree away. These are not required. So as far as assault part, there is no contradiction from Ali Akbar also. Then PW3. PW3 was also there in the mail and he also had narrated the same story that these people had said. And what he said, the difference that he has made is the uncle of the girl had initially ordered all of them to assault and then others assaulted. That I think stands contradicted. Lordship will see PW3 statement at place number 2021. He said that male was there was a love affair and then they got married. They should get married. And it was found no relationship. In the male, his son was proved to be innocent. Hazrat Ali did not give consent. Saina's uncle Ansar Ali got angry in the male and then Hazrat Ali left the bichar. Thereafter, Hazrat reached the house in front of the house of Ajizur. Accused Ansar ordered other accused persons to beat him up. And then the other accused persons had assaulted. That time, Hazrat and I, though I offered resistance, but I could not. They assaulted. In the cross portion also, Lordship will see at page 23. 6 lines from the top. We moved ahead about 1 rasi, and when we reached the front of the house of Ajizur, accused Ansar Bhuiya exhorted the other accused person to assault Hazrat and get the marriage solemnized on the road. In fact, on the following day, the marriage was solemnized. They forcibly got the marriage done. Lordship will see the contradiction as far as PW3 is concerned. Lordship will again go back to page number 55. 55, there it is Abdul Khalek. Yes. Abdul Khalek did not state to me the second paragraph. state to me that Hajrat did not accept the decision of the meeting and left the meeting and he came home with him. Witness Abdul Khalik did not state to me that he came after offering namaz at about so and so. But even this is not contradicted. Nothing is contradicted. Did not accept the decision and left the meeting. This is what the police had said. But all others have stated mail was over and they came back. Then PW4. PW4 is Mahidul Islam, whose 164 is also recorded and he is corroborated. Page number 26. Following the order of Ansar Bhuiya, other accused persons took my brother, Lordship, page number 26. The second line, following the order of accused Ansar Bhuiya, who is the uncle of the girl, the other accused person took my brother Abdul Rahim from the front road to the house of Arfan, brother of accused Ansar. The accused person intended to get my brother Rahim married to Arfan's daughter. My brother refused to marry as she was dark and all. But accused person intended to get their marriage solemnized forcibly, alleging that my brother had a love affair. Having received the information, my father went to Arfan's house and asked the accused persons why they caught Rahim. Accused persons told my father that my brother Abdul Rahim had a love affair and he should marry. Then my father said he had to ask Rahim. And when my father asked Rahim about this, he denied, refused to marry her. After hearing Rahim, when my father asked Saina about this, she asserted that there was no love affair. Having learned this, my father asked the accused persons why they were forcing to get the marriage solemnized. And when he intended to come to the house, after expressing his disagreement from the marriage between Rahim and Saina, accused Ansar exhorted the other accused person to assault the father. My father had already left Arfan's house, and when he reached in the front of Abdul Aziz, Ansar hit my father on neck, and when he fell down on the ground, immediately the rest of the accused person assaulted him with branches and lathis. At that time, I was with my father and tried to offer resistance. So he was very clear in saying the entire story. And he saw it. Yes, 149. One thing he says that when the mail was going on, no lathi or branches were there in the accused person's house. Hence, this is of course, this is the fact. There was no premeditation. They picked it up, whatever they got on their way. Yes, things got infuriated and yes. They flared up. This is the fact. There was some provocation. Although the provocation, both the boy and the girl said that we did not have any love affair. We were just talking to each other about other matters. But still, they forced them to get married. And when father disagreed, they...
34 today.
And they got married also on the following day.
Yes, 30.
After the incident. One of the witnesses have stated.
Could be a hotel.
Following day?
It is in the evidence of PW8.
Oh, Nissan.
Page 44 cross, my lord.
The marriage between me and Saina was solemnized at Arfan's house. Page 44, first line in the cross. At about 2 p.m. on the following day of the incident. And all the accused persons were present in the meeting. Oh, that killed over the meeting.
My lord, page 34. That exactly, my lord, because he died 2 days subsequent to the occurrence.
11th he died.
On the date of marriage, he was alive. Possibly they were not also expecting that he would die, my lord. And another aspect, my lord, she is very correct, my lord. Page 34, may I just read it once, my lord, how it happened? Exactly on the spur of the moment, my lord. 34 is PW4, my lord. Ocular witness, my lord. PW5, my lord. So if I read page 34, my lord. I went to attend the mail that day, meaning thereby he was at the mail. I went with Hazrat and others. I did not know it earlier that there would be a fight in the mail. When there was exchange of words in the mail, people got divided into two groups, one for marriage, one anti-marriage. We took Hazrat to his home in injured condition. Meaning thereby there was no premeditation that there be marpit in the mail.
There was no premeditation. This is what the common object is there. Lordship has seen the finding also. And they had followed, chased, and after that, everything happened. All these people were there. It is an admitted fact they had assaulted him, all 10 of them. But conversion can be only with respect to explanation 1 of section 300. That is grave and sudden provocation. Yes. Lordship will see 300 IPC. Exception 1. Culpable homicide is not murder if the offender, while deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or otherwise. I don't find anything immediately thereafter when they came out. Yeah. And Anfal's house he crossed, Ajiz's house he reached thereafter the incident happened. Lordship can see the sketch map. How far is Anfal and Ajiz's
So far as
house?
PW5 is concerned, my lord, it was marpit there in the end of the mail, my lord, that I read out.
End of the mail. Ajiz or Heri Ghoram was a different. Sketch map is at page 176.
Or common object can be for teaching him a lesson, not to kill him, my lord.
That Ajiz's house is at E. Ajiz's house is at E. Anfal house to control. Anfal house देखो ने? Anfal ने की? A indicates the place in Ajiz A. A. Place of mail is Anfal's house, no?
No, different witnesses have a different thing, my lord. Belek question, no? Place of mail to? Place of mail to belek question. Place of mail to different witnesses belek jagat question.
Etu kela.
Belek ghorot question.
Mail to put the name.
But Anfan's house.
Does not show anything as regards the place of mail, my lord.
Arfan's house is not shown.
Vacant lot towards west of the place of.
No, west of the.
A vacant place at the mail.
Anfan's house to look one.
No. Anfar house of course, Kumba ko belek signer house of probably question, no?
Signer bape Anfar. Anfar.
Signer.
I mean, unsafe.
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 Belek. Accused.
Oh, accused to. Anfar is uncle.
Belek ghorot.
Unsafe hai uncle? Oh, tomorrow uncle.
Tomorrow uncle.
No. Jitre mari bole bus. Swaljini uncle.
Some mail to belek. This piece of paper.
In front of the courtyard of Arfan.
Belek.
Etu tiniye kose. Sariye kose Arfan. Do you have a question?
This thing is like the
Arfana what?
expression.
So, they Arfane কৈছে, so.
লিখি আনিছো খালি সেইটো লৈ
Because
Signer to Arfan signer to not. Arfan signer to the heart. Hey, no. So I didn't say it. Arfan, I can't not even see Babego, floor to Babego. Arfan, so I said,
And the group, it was I think. Only rest of the. That the.
আজি মারপিট হয়েছে তো কালি দিনে এসে পুরো গেল
সেইটো নহয়, সেইটো নাই তো কাজি মাছ পঠাইছে। সঁচা, পিয়াজে হৈ গ'লে কেইটামান এনেও না আছে। Even sudden probably. আট বছর। আর 5 বছর কি হলো? 2 বছর না লাগে। Arfana le jeje sanao.
There has to be evidence.
Nossa.
নে
Ne?
আজি মারপিট লাগে
Kalim dia.
কালি বিয়ে হসপিটাল কেনেকে
Nisa to hospital him.
ডক্টর থেকে
Ano? Hindi na tayo examination. Nai.
No record in Guwahati Medical College.
Board
It was better.
Ten one or two course, eh?
জানাখিনি কলকাতা মেডিকেল কলেজের কোনো রেকর্ডে নেই
Okay, to his treatment at Borbata Civil Hospital. Person was not admitted in civil hospital. Pata ine nipla log usi boche.
Meditation.
এখানে প্রতিটা উইটনেসে বেলেগ বেলেগ কোচিং বলতে লাগে বা রোড হসপিটাল হয়েছে এটা কথা কিন্তু কোটি না পছন্দ ভাবা ইনভেস্ট করতে এটা এই জন্য আছে না
Aapko to police age. I have not provided medical leave. I cannot say whether the injury was treated medically.
Second day match is over. But Mr. B.K. Mahajan, like counsel appearing for the appellant, also had Mrs. Jahan, learned APP Assam representing the state, arguments concluded, judgment reserved.
Obliged.
highly available আমাদের
Yes.
Item 6.
Six and seven, my lord.
I have not seen this matter. Let him finish. I can reply.
It's it's a very small matter otherwise, my lord. Not much time, my lord. Only 3 witnesses, my lord. Basically, I am for the conversion, my lord. He was already in custody for nearly 6 years, nearly in 6 years. So, and there's a single blow. The eyewitness, there's only one eyewitness. He has also said single blow. Doctor also said the single blow, one injury. So basically, already 6 years inside the custody. A small boy, he was at that time he was 30 years old. There's a fight between the deceased and him, my lord, because of some tenancy dispute between both of them. And the resultantly, he gave a single blow on the head. And the
Blow by what?
by the lathi. Lathi.
So you are arguing for what? Conversion?
Conversion. Already 6 years, my lord, there's no question of acquittal here.
How long does it take you to read a paper book of this nature?
There are 17
At two.
witnesses.
Two months.
Go through it.
There's only one eyewitness, madam.
And for the. All right.
At 2
Take
Lordship.
it up.
At 2
You, in the meantime, you go through it because while he is arguing, you have to give us your assistance.
Lordship. Lordship.
Conviction.
Yes.
Trial fish person. In this case, the 4% was initially they have faced the trial, my lord.
Hmm.
And she has been acquitted, my lord. And out of that 3 acquittal, my lord, against 2, the respondents file an appeal against acquittal also. That is the next item. Item 7. That is Babul and Sukumar. And I've been.
Acha, Mr. Bora, just an estimation, how much time?
I'll
Because
not
there are
take
two
much time.
matters. How much
I'll only
time will it take?
three witnesses.
19 witnesses are there. 22, sorry, including.
Because if you can't conclude it today, we'll not keep it part-hard and it's going after vacation.
Well, Lordship, kindly see there is only one eyewitness in the whole case.
No, I followed, that's your appeal.
Yes.
These are all tagged, both matters are
Yes,
tagged.
but that is the only one eyewitness. He has deposed whatever he has seen, my lord. That will show everything, whether the rest has been rightly acquitted or not.
There is collaboration from other witnesses. Lordship has
All right,
told
then
the
let's
other-
see if you are willing to take that chance. Yes.
Now, while Lordship kindly take the page 4, my lord.
Hmm.
Ejahar, my lord. The Montu Kolita, my lord. He is a PW2. He has initiated the Ejahar, my lord, on the basis of the information given by the PW11. And there is a GD entry too. Prior to that, I'll come to that, my lord. With due respect, I beg to state that yesterday, that is on 25/10, I inform you that my brother Arup Kolita had gone missing. Today, after the recovery of the dead body at Meghai Boros Place, Ponds, behind the Haradhan's Bhomik's house near Gambura Weekly Market, we have got some facts regarding his death, and I felt it is necessary to inform you of the same. In the night of 19/5/10, while my brother Arup was having meal in the house of the Nandakishore Bhagat, he received a phone call from the unknown person, whereupon he left from there and saying that he would go home. After that, Sri Chandan Bhomik and Sri Babul Bhomik, son of Sri Haradhan Bhomik, assaulted him badly, struck him on his head. They were abated by the Sumande, Manikdesh and village. I came to know that this is Jatin Talukdar, that is PW11, who is a tenant of Haridhan Bhomik, witnessed the whole incident. So PW, on the basis of the PW11, this FIR has been initiated, my lord. And there's an also prior to that, there's a GD entry, page 176, my
So
lord.
he is an eyewitness.
No, he is not an eyewitness. He on the basis of PW 11. That is I have come to know from Jotin Talukdar. So Jotin Talukdar, PW 11 is the only eyewitness here. And prior to that, there's a one, my lord, lordship GD entry, that is page 176.
Yes.
Now the Montu Kolita, the Krishna Kanto Kolita Swenso has informed by submitting a written report at PPSC, accepting an invite that the younger brother Sri Arup Kolita took meal at night of Sri Nanda Kishore Bhagat, Sri Kishore Bhagat, by business of Gambura Daily Market Swenso on 18/5, that his brother was supposed to have spent night in his house. At that, when the younger brother received a phone call from an unknown person at night, he said that he would not be staying there and left it there by saying that he would be going to home. That the members of Orup's family thought that the Orup was at the house of Nanda Kishore itself, and that since the Orup did not return home till the morning the following day, the members of the Orup family inquired about him and got to know that Orup had left the Nanda Kishore's house at night itself, and since their Orup did not return, the members of the Orup family made an extensive search for him and could not find him. Accordingly, GD and entry is made Swenso. So this is the GD entry. Now, Lordship, can we turn to PW1, PW2, my lord.
So this GD entry was made on 20th or 19th. In the FIR, he says on 19th.
Yes. GD entry dated 20, my lord, 25/10. And timing of the GD entry at 8 p.m. Now, Lordship, can we turn to page 9, PW, page, my lord, page 11, my lord. He is the reported witness, my lord. He is the brother of the deceased, my lord. I know the accused person, namely Haradhan Bhomik, Chandan Bhomik, Pranjal Bhomik. Now,
Just 1 minute. Evidence of the case. My learned brother was involved during the trial. Will it have a problem?
Only recording the evidence probably, my lord.
Yes.
So is that a problem in the appellate stage?
The judges recuses, but I don't. If the judgment is delivered by the honorable judges, that is a ground, but depositions. Depositions of all.
There may not be. Involved in what matter? Involved with the trial. Involved with the trial. That is up to you. If you are accused, then. Otherwise.
Only one witness perhaps. Others were by honorable judge
Then
PJ
we'll continue.
Then, my lord, PW,
Oh,
What about you? Do you have any reservation on this?
PW2, my lord. I know the accused person, namely Sri Haradhan Bhomik, Chandan Bhomik, Pranjal Bhomik. Now, Pranjal Bhomik is the appellant, my lord, here. And Babul Bhomik. This is Arup Kolta was my younger brother. Incident occurred in 19/5/10 on the day about 8:30 p.m. My brother Arup Kolta went to the house of Nanda Kishore Bhagat for having dinner in his house and also staying there for the night. He did not return back to our house at that night. Next day morning, an inquiry over the telephone from the Nanda Kishore, he informed that on the last night Arup went to their house, but after the dinner he got one phone call and they left their house. We searched the Arup, but we could not find him. At noon, one Jotin Talukdar came to our house. That's important. Jotin is the PW11. And informed me that on last night he saw Pranjal Bablu beating Arup. He also said that the Haradhan Bhomik and Chandam Bhomik were also present. He also told us that the Haradhan Bhomik and Chandan Bhomik threatened him not to tell anybody about the incident and go and sleep. Later, when we asked the Manoranjan Bhomik, who was also close friend of my brother, Orup, about the whereabouts of my brother, he told us that yesterday night he went to the house of Haradhan Bhomik and he was beaten also. This Manoranjan Bhomik was not examined, my lord. I inform about the missing of my brother at Misamari police station. So, Lordship kindly mark one thing, that after the information given by the as per the PW2 by PW11, this FIR was or the GD entry was lost, my lord. But in the FIR,
No, but is there anything unusual about it?
in the FIR, they were silent about the incident. The incident they have narrated.
Hmm.
That part is FIR is missing, my lord. The incident, how everything has happened. And the GD entry particularly, my lord. GD entry also after the intimation also. But that
No, but PW11 is not an eyewitness.
PW11 is the eyewitness, my lord. He has informed PW2.
He is, the informant is not there.
PW2 is not an eyewitness. PW2 been reported by PW11.
Just a minute. We are asking who is the eyewitness? in-
PW11.
So
So
when
he
we
has,
asked a little while back, all of you said no.
no, PW,
Is PW11 an eyewitness? That
yes,
was
yes,
the question.
PW11 is the eyewitness.
You said no, why? Ah,
So he has informed to PW2,
hmm.
who is the informant. Accordingly, PW2 went for the GD entry and after the FIR also. But in the GD entry, they are absolutely silent about this incident way that he has described in the court.
That's all right. FIR is not supposed to be an encyclopedia.
That's true, my lord, but the information, that's a one thing, my lord, but I'm not on that directly, my lord. But whatever the incident, my lord, now dead body of my brother was found at pond, so and so, which is situated near the house of accused person. After that, I filed a written FIR at the Misamari. After that, I filed a written FIR in the Misamari police station. Exhibit 2 is the FIR. In my signature, police took the dead body from the pond and the police station and so and so. Cross-examination part, the police interrogated me in the police station. My brother was close friend of Manoranjan Bhomik. He frequently visited the Manoranjan's house. It is not a fact that I have not stated before the police that on the day about 8:30 p.m., my brother Arup Kalita went to the house of Nanda Kishore Bhagat for having dinner in his house and also for staying there for the night. He did not return back to our house at night and next day morning.
Yes, Mr. Bora. My brother is again having reservations.
May not be proper.
Bad luck.
Well,
Can't help. First time I somehow convinced him.
Because more than one witnesses I have recorded.
List this case before any other bench without one of us, bracket. Justice Mridul Kalita. Sri Mridul Kalita J. It will then come after vacation.
well.
Item 8.
POCSO matter, Lordship,
Yes, Mr. Manan.
Yes, your lordship, this is an appeal against conviction of the petitioner for 20 years.
Hmm.
On various sections, your lordship.
Which section?
The section, under the NDPS. The sections are, your lordship. He was convicted for 10 years under section 18C, 20 years under section 20B2C, and 20 years under section
You are ready
21C.
with the matter?
I have not seen this matter. That's what I was telling him. But I'll see when he does.
I have even brought a written argument for your lordships. so
Then
that-
tomorrow I can see it tonight. Tomorrow we can do it.
Oh, you go. Yeah, he can do it, your lordship. I have got it for the convenience of us.
Today actually I'm
Because
alone.
otherwise-
There's no one, so.
You want some accommodation, I have to, but I
Tomorrow
am ready,
is-
otherwise I can do the case. I
tomorrow
have
is
prepared this.
supplementary
We'll have
list.
day after tomorrow then.
Day after
They
tomorrow.
have to-
Heard Mr. Y.S. Manan, counsel for the appellant. Also heard Ms. S. Jahan Lanet, APP Assam, appearing for the state, who submits that she is not ready with the matter today. Full stop. As such, a prayer has been made to post the appeal for hearing again day after tomorrow.
Not
Prayer
allowed.
and list accordingly.
Much obliged. মই সেই written argument বনাই আনিছিলো, easy হ'ব।
Item 11.
Make please, your lordship.
Hmm.
My lord, here in this case, it is an appeal under section 302 lordship. There was an order lordship 10/9/2024. What has happened in this case, lordship, the learned session judge, additional session judge, while convicting the accused lordship, only 15 years was given lordship in lieu of life lordship.
Hmm.
For that lordship, but with all respect lordship, this is not a case of 302 lordship, because the only 3 battery torchlight was, as they alleged, used for as a weapon lordship. I have a written submission also in that, in this case lordship, for convenience of this honorable court. So,
You'll give it later. First, let us agree to hear your appeal.
sorry, lordship. And apart from that, lordship, my application for bail is also pending. Accused is 72 years of age, lordship, and co-accused already released, lordship. So question of parity is also there, lordship. Same out of same evidence, lordship, the learned session judge, lordship, consider him acquitted the other accused, lordship. And here in this case, lordship, the GD entry was made at Silchar, lordship. And those who are alleged eyewitness, lordship, here, they were one of the eyewitness, lordship, he was examined before the Silchar Gongur police under 161, where she has stated that he has not seen the occurrence, lordship. Only her husband told him that 2 days back, he was assaulted by the appellant and other co-accused, lordship. But while submitting before this honorable, before the learned court below, lordship, the learned session, before the session judge, lordship, she was claiming herself as an eyewitness. So it is a very, I might refer to submission. If these 2 eyewitnesses will go, lordship, it is a purely under section 304
What are
part,
the eyewitnesses?
as per the learned court below, lordship, the PW 1 and 2, lordship. And one point, lordship, I am clearing, lordship. GDNT was made 3 days back, lordship, and subsequently after postmortem, everything again, an FIR was filed, lordship. So here is also one legal point that the GD entry to be an FIR or subsequent FIR to be treated as an FIR in which the entire trial was continued and conviction was done, lordship, by the learned session judge, lordship.
Let us see what is PW 1 and 2.
One, PW one is page 9, Lordship. May I read, Lordship? That is, the disease Islamuddin Lashkar is my son-in-law. The residence of my son-in-law is at Hujai. After marriage, he started staying in my house and was doing business. I know the accused person Rahman Ali Ansari and Manikuddin, alias Ketli. The accused Rahman Ali is my neighbor. The residence of Manikuddin and Ketli is at Lalamuk tea estate, who used to sell fish at our village market. Accused Rahman Ali doing business of sweets as hawker. My son-in-law had introduced with the accused Rahman Ali. The informant Tafazul Ali Talukdar is the father-in-law of my daughter. About 5-6 years back, during a dusk hour, while I was in my house, I heard halla from the road near my house. Then I went there and saw the accused Rahman and one unknown person assaulting my son-in-law Islamuddin by means of a big size of torchlight and by means of a small weapon. I tried to dispense the accused but could not. Then my daughter Halima Begum came and able to dispense them. Thereafter, the accused Rahman and the unknown person left the place and bleeding started from the mouth of my son-in-law. Thereafter, we took him to the Lala PHC, where from he was referred to Hailakandi Civil Hospital. Then he was shifted to SMCH Silchar, but he left his last breath there. Postmortem was conducted and the dead body was handed over to us. The father of the deceased, after getting information, came to my house and lodged the FIR. Then cross, Lordship. It was a dark night. The incident occurred. My house is situated at a hillock. The road is on the bottom of the hillock. The way to reach my house from the road is slow. There are standing trees by both the side of the way. It takes 3 minutes to reach my house from the road. Immediately, my son-in-law was referred from Lala and Hailakandi to SMCH Silchar without wasting time. It is not a fact that I did not state before the police that one unknown person also assaulting my son-in-law by means of a small weapon. It is not a fact that I did not state before the police that I wanted to dispense the accused person, Rahman Ali, from assaulting my son-in-law. It also not a fact that I did not state before the police that my daughter was able to dispense them. It is not a fact that I did not state before the police that there was a bleeding from the mouth of my son-in-law. There are the landed properties belongs to me and Rahman, contiguous to each other. It is not a fact that my son-in-law died as a result of injury sustained by falling on the way of my house. There was a land dispute between me and the accused person Rahman Ali. As such, in order to take the revenge, I have deposed falsely, Lordship. Then PW2, Lordship. She was an inquest witness at Silchar, Lordship, before police, Lordship. I will supply the copy of that, Lordship, also. I know the accused person Rahman Ali, who is my neighbor and sells sweets in the locality. The incident took place 5-6 years back during dusk hours. At the relevant time, me and my mother were in the house. On hearing halla, my mother went to the road on the bottom of the hillock, and following my mother, I also went there. I saw the accused Rahman Ali assaulting my husband by means of a 3-battery torch. I tried to resist Rahman Ali and somehow I could resist him. Thereafter, Rahman Ali left the place and there was a profuse bleeding from the mouth, head and other parts of my husband's body. On seeing this, I became unconscious. Thereafter, my husband was shifted to the hospital and sent to the SMCH, and there where he expired. I know the accused Manik standing on the dock. Then
So
cross,
how many
Lordship.
persons have been convicted? Other persons unknown. He was not identified.
He was identified by PW1 only.
Who?
That other person, Lordship.
PW1 did not name him, said unknown person.
Accused
There was no TIP.
Manikuddin lordship. Manikuddin, and why, which was also admitted by the learned court below lordship, that only PW1 has uttered the name of the other accused lordship.
Manikuddin faced the trial,
Faced the trial lordship,
but was acquitted.
but he was acquitted lordship. And apart from that lordship, with all respect lordship, that PW2, while she was given the statement before the IO at Silchar Medical College lordship, just for clearing the basic facts before your lordship, I am supplying the copy of the evidences part of her before the IO lordship.
No, IO is not evidence.
No, that PW2 lordship, before the police lordship.
That
161.
is not evidence.
Not an evidence, but just to get the entire story, how she has stated subsequently as an eyewitness. Just for lordship, ma'am, consider, I am not on that lordship, only
It's all right, but we will go by, if there is contradiction, we'll take note of it.
lordship.
Otherwise, whatever.
Just, I will read that part lordship. It's also vernacular and I also make it in English also translation. No, just I am,
Is there any contradiction?
yes, lordship,
Then we
contradiction,
we'll look at the contradiction. Why do we need to look at 161 statement?
lordship,
If the witness has been contradicted, then you show us that.
lordship.
That is what we can take note of.
Lordship, just as a. My result submission, lordship, actually the trial was in a very peculiar way, lordship, which I cannot blame. But as per her person before the police, before the Silchar Medical College, lordship, that police was also not examined by the learned court below. Even the inquest was done, lordship, there at Silchar, lordship, that inquest officer concerned also not examined. And then postmortem only doctor. And that GD entry, nowhere in the judgment, it was mentioned about the GD entry that if the GD entry was made on lordship, GD entry was made on 13/5/2011 and date of occurrence was 12/5/2011, lordship. And FIR was filed on 15, lordship. So that on the basis of that GD entry, lordship, the police has examined her, that PW2, lordship, which she has stated here. Even police did not admit that there was a GD entry, lordship, PW11, who has stated.
Mr. Majumdar,
Lordship, please.
you see, you are free to argue the matter you want. We will not stop you.
Lordship,
But we have been telling the learned councils time and again.
lordship,
In every trial, you can find out 10 difficulties, deficiencies. That is not going to help. You have the evidence of PW1 and 2.
lordship,
At least to the extent of the appellant is concerned, there is corroboration
yes,
of these eyewitnesses.
lordship,
You have to tell us what is wrong, why this should not be treated as clinching evidence. PO has not done something, IO has not done this, these things keep happening.
no,
That is
lordship,
not-
with all fairness, lordship,
Hmm.
since while she is not a eyewitness on that count, I am submitting, lordship, while she has submitted before the
But she said, I saw the accused Rahman.
lordship,
No,
but
show us how, where she has been contradicted during cross.
lordship,
Hmm.
the way reach our house of the so and so, it is a dark night. Apart from me, my mother, the accused person, Rahman, there was none present. He is saying none present at the place, lordship. As I was become unconscious after seeing the blood, I could not say whether my husband was directly taken to the hospital or not. Our land and land Rahman Ali are contiguous. There was no dispute between me, we and Rahman Ali regarding the land. Mother was saying there was a dispute.
So she has remained intact, she has remained unshaken during cross.
Lordship,
We will not go by what she said or did not say to the IO. If you have not crossed her on that, that's unimpeachable evidence, we'll accept it. Or
lordship,
else you show us a judgment that even if there is no contradiction, if the witness has not said something to IO,
some
you have to put it to her and she has a right to explain it.
lordship,
If she cannot explain, then we'll draw adverse conclusion. That is the law. If you have not put to her, that means you also know she is saying the correct thing. Law operates on certain presumptions. Otherwise, there will be endless controversy.
Lordship.
She said something, you did not suggest that she was falsely deposing, means you have accepted it. Once you have accepted it,
Lordship,
you cannot.
Lordship, there is also a suggestion. I am suppressing the, there is no involved in the death of my husband. I am suppressing the fact of land dispute between we and the accused Rahman Ali, for which I have deposed falsely. After the husband, I married again. Just for Lordship, kindly allow me to what she has stated before the IO at CHR Medical College. Only truth is, I am not considering
No,
that.
we cannot.
Lordship.
Unless there is contradiction,
Lordship.
then we can look into the case study.
I,
Because statement made to IO is a part of case study.
Lordship.
Case study we look into for our.
But
satisfaction.
that was even GD entry and continuation of that was
Nothing.
not.
You show us a judgment
Lordship.
where the court can. Otherwise, sorry. You show us there is a contradiction and this contradiction is not in accordance with case study. So we will, just to satisfy our conscience, look into the case study. Otherwise, case study has nothing to do.
That is one
Case study has nothing to do in the appellate stage.
not in the, with all respect, Lordship, I admit that, with all fairness, just for,
She did not say it before the IO. So what?
no, even she was
said
not
something
present
else.
there.
She said she was not present there.
Lordship,
Still, we will not look into it.
Lordship,
We will go by what is there in the evidence.
Lordship, I admit that, just for, Lordship may not take into account of that, just I
What
am,
is the point in seeing?
Lordship, I with all fairness.
You have made so much of preparation. Yes, you read. But we'll not.
Sorry, so just Lordship, I am, with all fairness, I am trying to, Lordship, to,
See, she told the IO, I was not present in the place of occurrence. Let's take it that way. But in the evidence, if she said she was present
even,
and she was not cross-examined on that, we will take it that she is an eyewitness. That's
Lordship,
the law.
Lordship, I admit that. Lordship, with all fairness, she has stated there, Lordship, she was not present at the, in the place of occurrence.
Doesn't matter.
And apart from that, her husband told him that two persons beaten him and for which he was unwell and then he was taken to hospital.
Confronted with that.
Lordship,
He was no.
because 161 statement was not, GD entry was not considered by the learned session judge, Lordship. Subsequent FIR.
We are not concerned about whether he has committed the crime or not.
Lordship.
In every appeal, we are concerned about whether the charge is proved by
Yes,
evidence or not.
I am coming also.
What has actually happened? None of us.
Lordship.
knows.
Then Lordship
The
also,
courts are not concerned. That is how the criminal
and apart
justice.
from that, Lordship,
Many criminals get away because of this.
mistake.
We can't help it.
Lordship, but he is also, he was also darker, Lordship, the accused, deceased, Lordship, as per PW evidence of PW3, Lordship, in the cross, Lordship. PW3, page 14, Lordship. Kindly consider that,
Yes,
Lordship.
yes.
On the very relevant day, I found the smell of liquor coming from the mouth of her husband. There was no land dispute between Halima and the accused person. It is not a fact that since there was a land dispute between Halima and the accused persons are implicated in the instant case most falsely. There was a dispute with Halima and Rahman regarding the path leading to the house of the so-and-so. That PW3 says that he was deceased was in drunken stage, and then Lordship also, all are the PW5, 6, they are the hearsay evidence, Lordship, there is nothing to Lordship. PW9 says, I did not see who had killed the deceased. The house of accused Rahman is near the house of my sister-in-law. The house of my sister-in-law is on the hillock. It is not a fact that the sake of my sister-in-law I have deposed falsely. It is I have stated falsely in that my sister-in-law told me that the accused Rahman Ali killed her son-in-law. Then Lordship, the IO is the, medical officer is the PW10, Lordship. PW10. PW10, Lordship, the injury part, Lordship. Page 23, Lordship.
Yes.
There are one so and so, so and so, so and so, upper left side of the nose, nostril, so and so, one vibration, so and so, one mid front of the chest all. Then Lordship in the cross. Some of the above injuries may be caused to a person if the person falls on any hard object from a hillock. He was the victim, deceased was in Duncan stage, Lordship. Opinion of the doctor. Then Lordship, about the police IO, Lordship, page 25. First IO was not examined, Lordship, who has done the postmortem as well as inquest, Lordship, at whose instance he was not examined in this case, Lordship. Lordship, on 15/5 today, I was working as SI of Assam Police, Lalapur, Hailakandi. One so and so FIR was lodged. On receipt of the same, the said Ejar was registered as so and so against Rahman Ali Ansari and Patal Ansari. Detail of the Ejar being empowered, I undertake to investigate the incident. I recorded the statement of the available witnesses and draw a sketch map of the place of occurrence. I also made arrangement for conducting inquest upon the dead body. Lordship, he is at Hailakandi, and inquest was made at Silchar Medical College. With all respect, Lordship. And postmortem, everything was done. How he can arrange, Lordship? He has come to know only on the FIR of 15 subsequent FIR. The DNT, everything was done at Silchar, Lordship. I also made arrangement for conducting inquest upon the dead body as well as so during I apprehended the accused person on my transfer. I handed over the case ID to certain successor in office in cross, Lordship. The alleged incident occurred on 12/5/2011. There is no separate GD entry, but in fact there was a GD entry, Lordship. I'll come on that also. In a connection with the alleged incident, the PW1, Moina Bibi Ansari, did not state me that her son-in-law was assaulted by one unknown person, also with a small weapon. She wanted to dispense the accused person, Rahman Ali, from the assaulting her son-in-law. That her daughter was able to disperse that there was a bleeding from the mouth of her son-in-law. Then, Lordship, last paragraph.
Yes.
I did not seize any weapon alleged used in the incident. That very torchlight, Lordship. It is not a fact that I did not inquire the incident properly and file the charge sheet without proper investigation.
Yes. He is the first IO. Is the first IO or second IO?
He is the first IO is at Silchar, second IO at Hailakandi after filing the FIR. Then first IO was not examined, Lordship. Silchar, who has done the inquest as well as the postmortem, Lordship.
No, Mr. Majumdar, you see, there is one problem.
Lordship,
You are pointing out this has not been done, that has not been done, but you have to tell us what is the impact of that and what is the law in your
I am
backing.
coming on that also, Lordship. Just I have made it, Lordship.
Supposing this was not done, then also so what?
Lordship, I'll also make in my written submission, Lordship, all the judgment also for convenience of this honorable court. If please to consider that also, I'll supply that. I'll go through with that, Lordship. Then, Lordship, in the judgment part, I am coming, Lordship. No. He's on area, second IO. I'm coming.
Things are not very clear.
Nayanmani Singh, he is the second IO lordship. Last IO is another person lordship. I handed over the case to the successor in my office.
What first IO, second IO? HR was lost on that day, 15/5,
15/5.
2011. And then police case was registered. How
Lordship.
can there be IO before that?
There was a GD entry lordship. On the basis of, I'm coming lordship, I'll try to satisfy
This guy is not IO.
lordship. After GD entry, there was
Here, otherwise you will cause damage to your clients.
lordship please. I'll also coming lordship. Huh? Exhibit 1I. Here is the record is there lordship. I have seen it. I flag marked it. Lordship, page 58, Lordship. The defense also argued that the prosecution failed to seize the torchlight by which the accused person Rahman Mia assaulted Islamuddin Talukdar, and for his defeat, the case of the prosecution is bad in law. In this regard, it is put on record that all omissions on the part of the investigating agency do not become fatal all the times, Lordship. Then, Lordship, how the other co-accused was page 59, Lordship. The co-accused Malikuddin Patel Ketli is implicated only by PW1 and none else. There is a lack of corroboration in respect of the allegations.
You are
against
reading from
Malikuddin.
which page?
Page 59, Lordship, of the paper book, Lordship. Paragraph, it is,
That is what judgment of the trial court.
yes, Lordship. Paragraph 16, conclusion. In the case in hand, all the witnesses implicated the accused person, Rahman Mia Ansari. The accused Malikuddin Patel Ketli is implicated only by PW1 and none else. There is a lack of corroboration in respect of the allegations against Malikuddin. There is no strong evidence that the accused Malikuddin also took part actively in assaulting the accused Islamuddin Talukdar. In such a situation, there appears a doubt about his involvement on the death of Islamuddin. As such, so from the charge under section 30234 IPC, Lordship. My lord, page 65 is the inquest report, Lordship. I'm just,
What is your submission, Mr.?
I'm
You are
coming,
jumping
Lordship.
from here to there, here to there.
just
Till now, we have understood nothing of what you submitted, nothing.
my submission,
So maybe when the judgment comes, you will be surprised.
Lordship,
Not making any sense. Either you recast, properly argue the case,
Lordship.
or else we are not understanding what you are saying. These
Ma-
are all, this has not been done, that has not been done. Oh, so, okay, no, not done, fine.
My restitute submission.
There are two eyewitnesses. In case of your client, there is corroboration of eyewitnesses. Their testimony has not been shaken. We'll uphold the conviction unless in next 10 minutes you can tell us what is wrong with this. This IO has not done this. He has not made this recording. These are not going to make any
Lordship, the
difference.
with all fairness, Lordship.
Fundamentally, you have to show what is wrong.
Wrong in that sense, Lordship. First of all, there was an, during that point, Lordship is not.
If
that
you are not ready, we recommend you better study your papers properly.
Lordship.
Otherwise,
Lordship, I
made up our
if I
mind,
mistake,
what-
Lordship, with all fairness, Lordship, I'll try to rectify it.
your arguments are not making any sense to us. And we
Only-
are concerned because
Only
it's a
thing is that, Lordship,
life imprisonment, is it?
life, Lordship. Only thing is that whether this preliminary thoughts and intention of the accused to kill the person.
Absolutely. The answer is yes.
Lordship.
Yes. We'll say yes. That is the only thing we are giving the answer.
No, Lordship, I am not.
Let us try it. Put a 3 battery torch in somebody's head. Will anybody take it?
And apart from that, Lordship,
Hmm.
the intention of the accused. is-
Show us from the evidence. What is the intention? It doesn't matter here. If there are eyewitnesses saying that this person has hit the accused in the head with 3 battery torch,
Lord,
you can only get away with the exceptions, nothing else. Intention, obviously it is intention is there. You have to show that your case comes within the one of the exceptions of section 300. That is the only argument you can make. You are saying
Lordship-
all kinds of things.
Lordship,
There's
just
nothing to.
300 in that sense, Lordship, regarding his sudden provocation on that point also. All right, today, if Lordship another time may be given, Lordship, I shall try to satisfy your
It's up
Lordship.
to you.
Lordship, please.
Otherwise, we are telling you because
Lordship,
all arguments you have made, your appeal will be dismissed.
Lordship, I may be allowed some
These are
time.
no arguments at all. These are no arguments. In a
Lordship.
criminal appeal, these are no arguments.
I shall
This
try to,
prosecution case is based on
Lordship.
eyewitnesses, corroboration, medical report establishes it's a homicidal death. Strike in the vital part of the body, in the occipital region, the doctor has said. What else is required? You have to show that the witnesses are telling lie. Otherwise, it's done for you. You have no chance.
Lordship. I said,
You are not even arguing. You are saying the first IO has not gone to Hailak and the second IO has not slept in Silchar.
My,
What difference does it make?
my respect to submission,
Hmm.
I shall try to satisfy any other day, Lordship's convenience of this
Any
honorable.
other day.
Lordship,
Any other day will be after vacation then.
Lordship.
Because there are some
Because-
parted matters which are
Yes.
fixed. And we will write all judgments we would like to deliver
Lordship.
before vacation.
No, Lordship, after vacation any day.
When do you want it? Tell us when. When do you want it after vacation?
Before vacation, not possible, Lordship, because short time is there, Lordship.
Where is the time to write judgment?
Lordship. Convenience of this honorable court, I pray, Lordship.
And we must
Huh?
tell you that you need to work hard on your matter. You
Lordship,
must
Lordship, please. I agree.
Make
Lordship.
out.
Surely,
You are
Lordship.
arguing 1 or 2 appeals, we hear hundreds. You are not at all ready with your brief.
Lordship.
This will not work here.
Lordship.
If you think that you will just say whatever you feel like.
No,
and
no,
the
no,
judges
no.
will write
Lordship.
judgment, that's not happening. You are having a difficult case. A very tight case.
Lordship, please.
There are eyewitness, there is corroboration, they have not been contradicted. There is no suggestion that a particular deposition is false. Omnibus saying that they were not involved. Merely by saying that your client doesn't get away. You have to then show from the materials that this suggestion was made to fit it into this scenario. I don't think you are aware of this
Lordship,
legal
yes.
principles. You are
I,
just showing one here, one there. That doesn't make any difference. It's not a
Lordship.
game of chess. Somebody has lost his life. The
Lord,
trial
Lordship.
court has
I should try.
given a
Lordship.
judgment on finding. People have said they have seen the occurrence. They have given description. One of them might not be able to identify the other. All right, acquittal, no appeal. That's how state functions, or at least used to function those days. But what about the appellant here? Against him, there is corroboration of testimony of eyewitness. No confrontation in the cross-examination. That's the end of the matter. End of the matter. You just have one chance to come up with something substantial.
Lordship.
You have not even argued anything which is even remotely substantial. Forget substantial. Therefore, we are saying otherwise we can deliver our
No,
judgment.
Lordship,
I can dictate the judgment.
Lordship, I admit that, Lordship.
You want to
I
do it
need
up
some
to
time,
you.
Lordship, to try to satisfy Lordship.
Better do it.
Do it, Lordship. I should be.
Please remember, in murder case,
Lordship,
eyewitness,
please, I know.
very difficult.
Question of-
Acquittal, very difficult. And you are arguing for acquittal, is it not?
Lordship, that is alteration of the Lordship. I pray, Lordship. Acquittal may not be,
What is-
Lordship.
That's what we are asking you. Which ground?
Ground is that, Lordship, the T04 part 2, it can be
302
lost.
part 2. Then it has to come into within the exceptions. Which exception?
Exception, Lordship,
Which one?
just
Which exception? What are you looking for in your paper?
Lordship, the
Exception of what?
exception of, that is
Exception laid down
in 300. Sorry. 30 4 part 2 lordships, exception 4, I think lordship. Huh?
Mr. Majumdar, that's why we are saying again and again,
Lordship,
you are just taking a chance. You are not at all prepared in your matter.
let me lordship.
You don't even know which section there is exception.
30,
You don't even know which is the section in law which provides for exception. You've
lordship,
taken a big risk trying to argue this matter before this court.
lordship, please.
304 doesn't have exception.
300. After vacation, lordship, I'll sit, I see him
You
then.
could have said it in the beginning. Yeah, you are not prepared. Without preparation, you cannot do court in
Lordship,
this
please.
case in this court. It's not possible.
It's sorry, lordship.
Don't try it. Don't even attempt it. So and so on the request of Mr. Majumdar, learned counsel for the appellant. Party Nam to Didibo, the appellant for the state. On the request of Mr. Majumdar, let this matter be listed for hearing again after the winter vacation. I'm not making it part of because I don't know the bench.
Lordship.
Otherwise, your client will get stuck up. If another bench comes and then the matter will not be listed for long. So
Lordship,
it will be listed. If the same bench is there, it will be listed on the same bench. All right.
I'll try to prepare, lordship.
You have absolutely not prepared. You just glanced through some evidence and you thought you will say this and that. Nothing. These are serious business. When you are arguing a criminal
Correct,
appeal,
lordship,
life imprisonment, you must know everything like the back of your palm.
lordship.
What is your argument? What are you going to argue? A criminal appeal where you can't convince the court in 5 minutes is going to lead to dismissal. At least in this court, this will happen. In 5 minutes, if you can't hit the nail on head, your appeal is going for dismissal. You just have 5 minutes, just the bullet points, rest are mere details. After hearing you for 1 hour, you could not give 1 point on which your client can be acquitted. That means either there is no point or you are not aware. So it will be injustice if we don't tell you this. You will not even know. That's why we told you. All right.
Lordship, sorry, lordship.